for the respondent to file, my lord, affidavits within 2 weeks. My lord, I was being led by Mr. Bose in this matters. My lord, Mr. Roy Chaudhary took time, my lord. They have not filed affidavit. Lordship had kept it on 15th of September, my lord, considering the timeline that
perhaps is
affidavits
not
would
correct. My lords, we are out of time. That's correct. But one matter has been fixed on 3rd and one matter has been fixed on 12th. My lord, we'll need some time because my instructing client, my lord, who is there, my lord, he is obviously not in the country. So, my lord, we are just waiting for that. We've shared the draft also with him. We're just waiting for that.
My lord, we were actually
to be mentioned. Let it
Very
come.
well. Grateful to you, lords.
May I, my lords, kindly to mention matter I'm mentioning upon notice for inclusion in the list. Well, it was before another bench because it was part heard. Part heard has been cancelled, my lord. Great.
My lord, may I have my lord's leave to mention this memo, lordship? There are 2 impugned orders, lordship. I want to file without the certified copies, lordship. I was humbly praying for leave to file.
When were the orders passed?
Lordship, the order was passed on 31st of July and the other one was on 19th of August. Lordship, I have already applied for.
Very well.
There are 2 appeals, my lord. I'm grateful.
Number 1.
Yes. You'll. Oh.
Well, I am for the respondent.
You have only restricted your challenge to claim 4.
4D.
8 and 9, my lord, with regard to interest.
And 4 was overrun.
Yes.
Additional
The-
cost.
But the 34 court has reduced this interest, my lord, because the interest component is already included in the
Yes.
what?
This appeal, section 7, Arbitration and Conciliation Act 1996. Hereafter, the said Act of 1996. Please challenge. Order detailed. April 24. April 29, 2009. Passed by the Senior Demand. In this case number 5 of 2006, whereby the appellant's appellant's application under section 34 of the said Act of 1996 was disposed of by modifying the arbitral award dated January 31, 2006, passed by sole arbiter. Some of the facts of the case, so far as they are relevant for adjudication of the present appeal, are as follows. First time. A tender was floated where your client was successful.
Lordship, my client was L1, my lord.
Appellant.
এই জিনিসটা যদি লিখি তাহলে তো আমাকে এই অর্ডার অনুযায়ী পেজ 202 পেপার এখানে বলা রয়েছে কি before the 55 lakh না registration keep the service because renewable deposit till disposal যদি আমি দিয়ে দিতে আমাকে তো রিএমবার্সমেন্ট চাইতে হবে
Scheme.
আমাকে ফেরত দিয়ে দিন আমাকে আমি তো পাবো এটা ওরা তো ডিপোজিট করেছে
District
স্টেট ডিপোজিট করেছে হ্যাঁ সেই
respondent participated in the
এক্সিকিউটিভ কোর্টে চাওয়া আছে আমি শর্টে মারতে চাইছি এক্সিকিউটিভ কোর্টে তো আমার 1 কোটি 28 লক্ষ টাকা আউটস্ট্যান্ডিং
awarded.
থেকে এটুকু তো পারি
Now the contract for the aforesaid was awarded to respondent. Paragraph. Disputes and differences arose between the parties relating to the execution of the work.
অরিন্দমের উপরে আমার 5 নম্বর আছে এখানে কেউ ট্যাক্স না বলছে
In terms of the arbitration clause contained in the relevant agreement governing the parties, an arbitrator was appointed and the disputes arisen between the parties referred to the arbitrator for adjudication there. Full stop. Paragraph. The respondent here filed statement of claim, laying as many as 9 distinct claims, which are as follows. A paragraph 190. The list of claims there. It should be claim below copy holder. Paragraph. The appellants contested the respondent's claims by filing their counter statement. Paragraph. The sole arbitrator ultimately disposed of the arbitral proceeding by an award which was made and published on 151, 2006, whereby thereby allowing claim numbers 4, comma 8 and 9.
What the-
There is a statement of this.
ফিফটি আনতে ভুলে গেছে হ্যাঁ একটা পেপার দিবা Lord, your lordship will get the claim number 4, the additional paper book, page 31.
Shall apply. Admission.
Yes. দৃষ্টান্তগত স্বপন ব্যানার্জি তখন কোথায় দুই চলছে আমারও চলছে 28-এ ওটা আমারও মামলা কি বলছে ঠাকুরা এসছে বসে এসছে Yes, sure. One that আঠাশে কি হেভি করে আমাকে
My lord, your lordship has allowed the appeal or dismissed. My lord, we have not been able to hear.
Dismiss.
My lord,
Dismiss.
in such an event, my lord, being an award holder, my lord, kindly come to page 202, order of 22nd of July 2013. My lord, by that order, the state, the appellant deposited a sum of rupees 55,96,844, the principal amount, in a interest-bearing security with the Registrar General. My lord,
Execute the award. Execute the award.
my lord, in fact, the
That security is lying.
execution application is pending before the other court.
Activate it. Activate it. Take the money with court's leave.
My lord, if your lordship kindly make one line observation, my lord, I am entitled to get the refund of that.
Mr. Sen, your application is pending before the learned single judge. Execution. Activate that. Obtain an order on that application. Take the money. Money is lying there.
Yes.
And Mr. Dotto, we have recorded that there was no serious challenge thrown to the other part of the award apart from claim 4.
My lord, I'm sorry, my lord, I got delayed. My lord, the claim number 8, which we have challenged, my lord, claim number 9 is granting of interest. So, my lord, claim number 8 is overlapping. My lord, that was
So
the
that has been
crux of the
reduced. That
challenge.
has been reduced.
So that was reduced, but my lord, the question is that once you have granted interest on a delayed payment, you cannot again grant interest on a different score. Well, that was the crux of the challenge regarding claim 8. Claim 4 was, my lord, that gap in reasoning as... Mr. Dotto, we have recorded our reasons. Very well, my lord. I bow down. Next, Daku. Great.
My lord, this is an application for modification of an order.
That very innocuous application, your lordship.
It have before original site. Yes.
My lord, they have sought for, my lord, a modification of an order, which your lordships will recall on 12th August 2025.
1 second.
Always possible.
Yes, who has applied? Whose
Well,
application is this?
The appellant, my lord, has
Yes,
applied.
yes.
My lord, lordships had, my lord, in paragraph 15 of the order at page 18, lordship kindly comes to page 18, recorded that the impugned order passed by the, my lord, Barashat court cannot be sustained. And, my lord, in the event, we, my lord, intend to remove it. In paragraph 16 of the order, lordship had permitted us to remove it, subject to an inventory. And thereafter, my lord, the only embargo put on me is not to dispose it of till the commercial court Rajarat finally decides. My lord, we write to them, my lord, stating that we would, my lord, want an inventory so that we can ultimately remove it and indicate a date. My lord, there was a dispute with regard to the date. They said, my lord, they have the right to, my lord, indicate what date they would, my lord, have their agent present in the property for inventory. And, my lord, they also said that I have to indicate where I am keeping the, my lord, equipment, the mobile infrastructure, which is not provided for in the order. Hence, my lord, I have come up with the application. Now I understand, my lord, they are agreeable to a date. He indicates, my lord, he has spoken with his clients this Saturday. My lord, I have also agreed, my lord, I have convinced my client this Saturday. Kindly, my lord, records that, my lord, Saturday we will go inventorize the equipment and we'll remove it.
Can 2
This is can 2, my lord.
issue.
The only difficulty if a prior notice may be given to us as well.
This is the notice itself.
This is the
When
notice.
Time indicating the time when they
We will indicate a time. Don't make things difficult. This appeal was disposed of by our judgment and order dated August 12, 2025. Stop. Paragraphs. No, paragraph 16. Paragraph 16 of that order reads as follows. আগের অর্ডারটা থেকে paragraph 16টা দিয়ে দিও. Next. This application has been taken out by the appellant.
Their email is at page 22 where they took that stand.
Page
22, my lord,
22.
in response to my request. One sentence paragraph, I shall inform you of the date and time that is convenient for my client for the email.
Alleging that the respondent number 1 herein was not agreeing to a date on which the concerned equipment could be inventorized and then taken away by the appellant. Stop. Paragraph. Today, learned advocates for the parties tell us that the parties have now agreed on the date. Stop. What is the date?
30th of August, Saturday.
Stop. On August 30, 2025, the concerned equipment will be inventorized in the presence of both the parties, and then the appellant will be free to take the same away, subject to the conditions mentioned in the earlier order dated
Well, that order is dated 12th of August,
August
2025.
12, 2025. Paragraph, hence, nothing remains of this application.
Only the
Stop.
time may be mentioned.
Inventory of the concerned equipment will be prepared on August 30, 2025, at 11:30 a.m. 11:30 a.m.
And we'll provide them with the particulars of the persons on our behalf who will visit the site on that date.
Stop. At least 24 hours in advance, the appellant shall provide the particulars of its agents who will be present at the time of inventorization of the equipment. Stop. No further notice will be given to either of the parties. Stop. That's all.
Well, there's a lock and key. They have to open that. Well, in the event they are
have
not
to.
only one.
The respondent number 1 undertakes to extend full cooperation for the purpose of inventorization of the concerned equipment, after which the appellant may take the same away. Stop. If the equipment are under lock and key put by the under lock and key, put by the respondent number 1, needless to say that such lock shall be removed for the purpose of carrying out the order dated August 12, 2025, read with this order.
Grateful, my lord. Deeply.
Application disposed of. Appeal has to be heard out.
Yes, my lord,
Your claim has been rejected. Counterclaim has been partly allowed.
partly allowed.
So file informal paper books.
Yes, we do that only, my lord, for the stay purpose, for the purpose of stay.
Yes, the cost. Don't insist on the cost immediately. We'll be hearing the appeal.
And also, my lord, there is an order passed by a coordinate bench. My lord, what happened here was that earlier their counterclaim was allowed ex parte. So, my lord, we have preferred a recalling matter went up in appeal. There was an order directing me to secure 8 lakh rupees, my lord, and that security is still subsisting. This is the order, my lord. There's not annexed. Yeah, sorry, my lord. One order is
Yeah, the decree in your favor is for how much?
principal 3 lakhs.
Works out to, my lord, about 16,83,754
With interest.
with interest in terms of the decree till the date of decree.
How much security is there at the moment?
I don't know, my lord.
My lord, this order, I'll just share. This is the order. 8 lakh rupees since 2019 is lying as security. My lord, kindly see, my lord, page 5 of the order. I'll just in between, my lord.
This was an appeal preferred against what?
Preferred against, my lord, when order whereby, my lord, the counterclaim was decreed ex parte. So I was, my lord, given, it was recalled subject to me depositing, securing the counterclaim, the 8 lakh rupees,
And was remanded again.
and was remanded again, and was given liberty to use an additional WS, which I have done thereafter. And then, my lord, on context, my lord, this has happened on contest. This is, my lord, lying. This is
Principal is how much, Mr. Middle?
3 lakhs.
The principal is 3 lakh, but it's a long outstanding claim. But too small.
You put in 8 more if you want to stay.
My lord, 8 lakhs already put in 2019.
Very well. Put in some more.
And my lord, that possibly would also interest possibly is accruing on that also. It's 2025.
Yeah. Maybe it has become 10 or 11. We don't know.
And now, my lord, the interest of 24%, there was also, my lord, an issue there because the learned judge has gone on the basis that there is a concession given an admission in another proceeding, which possibly
That will have to be heard.
that will be heard. I understand. There's a
I must also point out, my lord, out of fairness, my lord, I have preferred a review against the decree that is pending.
Acha. Right.
My reviews in respect of a very small point. Certain payments have been adjusted. Those payments, my lord, according to me, have been wrongly adjusted against the principal first. In my humble submission, they ought to have been adjusted against the interest which had accrued.
Then till such review application is decided, you shouldn't be allowed to execute the decree.
To the extent I've succeeded, I'm always entitled to execute. If I succeed in my review, it will go up. It will not come down. So I should be able to first execute and thereafter again execute.
We need to know how much that 8 lakhs has become now.
will, my lord, take a little bit. It is with the registrar original side. It was
If you can come back with that instruction at 2 o'clock or before we rise, then we can dispose of the stay application,
yes, my lord.
direct filing of informal paper books, and whatever extra security we feel. But we should know then how much is lying now.
Lordships may consider calling for a report from the registrar.
Informally, can't you find?
Informally, my lord. My lord, my advocate on record is not very confident, my lord. I must about that. My lord, may call for a report, my lord. That possibly my learned friend is correct.
This appeal,
Cost has been awarded in my favor, Milo. Let them pay my cost, Milo.
are you serious? We will be hearing the appeal.
I am implicated in the matter, Milo.
This appeal is This appeal is directed against a judgment and decree dated July 7, 2025, whereby the claim of the appellants / plaintiffs has been rejected by the learned single judge. Stop. The counterclaim of the different number 1 has been partly allowed. Stop. Costs have been awarded against the plaintiffs. Paragraph. We are told that earlier, the counterclaim of the defendants had been decreed ex parte. The plaintiffs had challenged such ex parte decree before the division bench by an order dated February 26, 2019, the division bench had set aside the decree and remanded the matter to the learned suit court for fresh adjudication on condition that the plaintiffs will put in rupees 8 lakh
8 lakhs.
with the registrar original side.
Registrar, yes, registrar.
Registrar, original side, Calcutta High Court. Such money was deposited and is deposited with the registrar, original side, and still lies with him/her. We are sure the money has been invested by the registrar. Paragraph, learned registrar, original side, Calcutta High Court, is requested to file a report on the next date, indicating how much the said sum of rupees 8 lakh has become, along with interest. Paragraph, list this matter once again. Friday. Friday date diye dao. Paragraph.
29th.
Learned advocates for the parties are requested to immediately communicate this order to the learned registrar, original side, Calcutta High Court.
Grateful, my lord. And it's an understanding between us, my lord, that it's
pending before us.
Yes.
Lordship, I'm appearing for the appellant.
Yes.
I'm appearing for the appellant, Lordship. I'm praying for a short passover, my lord. I'm being led by Mr. Joydeep Kaur.
Passover?
My lord, I'm appearing for the respondent, my lord. I'm led by Mr. Rafsanko Banerjee.
Mr. Joyanto Mitra?
Lord, he's concluded. On the last occasion,
Oh,
we
he has
were supposed to start. My lord, I understand, my lord, your lordships do not permit a relay race, my lord. Therefore, I'm seeking a passover, my lord. My senior is on his way.
Passover? এই পুরো লিস্টটা একবার দেখে দাও।
Item number 4, happy progress. Item number 5. Item number 6. Item 7.
7 not appear for the respondent. 8 not appear for the appellant. 8 I appear for the appellant, my lord. That's that construction matter, my lord, which I was having.
Second call. Relax.
12, 13, 14, 15, 16, 17, 18, 19, 20. Second call, we have to item number 2.
What 2?
We're being led by Mr. Joydeep Kaur.
You've been told that once.
Yes, my lord.
What do you want?
My lord, actually, in the appeal, my lord, it is
an appeal from.
Will you argue or you want an accommodation? Please do not consume time unnecessarily.
My lord, can it be kept tomorrow, my lord?
Yes, can be. Not today.
Grateful.
Lordship, item number 16 and 17, Lordship. I'm appearing for the appellant, Lordship, in this Lordship. This is a very old matter, Lordship, and it is part. There are 2 Section 37 application, Lordship. So, Lordship, I'm praying for 1 week accommodation.
Second call 3 Dugway.
We have to commence our arguments. This is.
Yes. Did you start? You haven't started?
No, I haven't started. This is for setting aside of the award which we have got. We have been, first court, at least, held with us.
Flaring up the gas. Flaring up the gas. That's the matter.
Yes.
27 point some percent or 28 point some.
24 point correct.
24.
24, oh, sorry, 28 point, correct. 28 point, correct. More accurate than I was. Lord, 3-4 issues, which I just wanted to first point out. Recall, this is a sale and purchase of gas agreement, which was to run. This is CBM gas, which was to run till 2034. The agreement is dated 2011 and was to run till 2034. The agreement, one of the features of the agreement, and which is very important, it has something called MGO, minimum guaranteed output, which basically means offtake, which basically means that even if they are not to take.
Before you proceed further, for the benefit of your friends, will you keep us busy till recess? No, not really. No, then we could release your friends.
12:30.
12:30. Very well.
Great. So, the minimum guaranteed offtake provides, that's a clause which negotiated between parties and agreed, which provides that irrespective of whether you take any gas or not, but you will have to pay a minimum guaranteed offtake to me or amount to me. And this is has been the feature, and which has also been noticed by court. This has been the feature of a lot of agreements like this kind of agreement, where there's gas supply or even electricity. Because there are 2 or 3 reasons for that. One, gas, when it comes out, even electricity, in that sense, when it is produced and all that, it really cannot be stored in that sense. It has to be used. Second of all, you also invest in the infrastructure to provide this supply of gas or whatever it's. And thirdly, we also pay royalty, which is irrespective of whether we sell or not. That has to be paid, and that's recognized in the Delhi High Court judgment. Also, they say yes, these are the sunken costs which one has to have. So, therefore, more reason why you have long-term agreements, so as to insulate you against this variation with regard to that you have someone who will, at the minimum quantity, will be taken from you. This was really the purpose of this, and this is whatever I'm submitting is there found in judicial acceptance of these clauses. Now, in 2014, 2011, we had entered into the agreement. On 25th April 2014, they entered into another gas supply agreement with SR. And this is very important. All this is on facts here. And we were not aware of it. And they had also given us 2 bank guarantees for the purpose of covering this minimum offtake. No, it was given 2 security bank guarantees were given, not to cover the whole amount, but something to that extent. When we asked them to renew it, they said, let us have you do away with the minimum guaranteed offtake clause and let us renegotiate on this. Because would fine, and why I'm saying also, I'll explain why I'm making this point. Then there were a whole lot of letters which were extended. And we said, very well, if you want this clause to be taken away, you increase the price of the gas. If you want this clause to be taken away. We were not aware, they have entered into another agreement with SR. Then they did not agree. And finally, nothing happened with the negotiation. The contract went on. They did not renew a bank guarantee. Then what they did, they went to court. The civil court, before this honorable court. And they said that please supply us gas till 15 July. By 15 July, whatever guarantee they had given, that would have got exhausted. And we are looking for another supplier. This is the court order. And in the meantime, they terminated our contract. This is not on 7 July 2014. They already had on the 25th of April 2014, because this was discovered accidentally when they produced the third witness, which in fact we had opposed. Mr. Beriwal, he had come in, and that's where we found out that there were also a question of having another agreement. So this was the situation. Now this is an executory contract. In the sense of as we know, in a contract, either there's a reliance loss which is given, or expectation loss. Because here, if the contract had been performed up to 2034, I would have gone on getting this minimum guaranteed output, irrespective of what they did. So our claim, first we obviously said that this termination is illegal. Because there was really no reason why you could have terminated an agreement which has already been entered into. Because you enter into an agreement, someone else doesn't mean this can be terminated. Secondly, we made the claim either specific performance or for the entire amount up to 2032.
34.
Sorry, 2034. Because we said we are entitled to it. If it had continued, we would have got the entire thing. And which is a substantial claim. I'm not shying away from that. Yes, that's the claim which we made. The arbitrators, found, first of all, in my, before that, what they did, they challenged this clauses of this agreement, saying it is against competition, unfair, before the Competition Commission. It was through an employee, but the Competition Commission held that it is really you who are challenging it. And that's how that other series of litigation comes in. So they challenged it before the Competition Commission, and the Competition Commission held in my favor, saying that no, these are usual clauses in a gas supply agreement because it's a long-term commitment which one has to make, and also holding that MGO clause as well, it's not unfair, and also they're recording that after the termination there has been flare up, because this has also been quite an issue here before my lords, because this is not what they argued before the first court. First court was entirely different argument. Entirely different argument.
First court was the High Court.
This was one of the arguments, but I'll tell what was the main argument which they made there, because that also went on. So Competition Commission, we succeeded. Delhi High Court writ, has also been taken to the Delhi High Court writ which they filed, challenging that. First, Appellate Tribunal, Competition Appellate Tribunal, that also got dismissed. Then the writ has also got dismissed, holding certain things in my favor. Now, so the arbitrators have found, first, that yes, the termination is wrongful. Considering the clauses of the contract, interpretation of the contract, it has been found there's a finding with regard to that the termination is wrongful. Now, if the termination is wrongful, then quite naturally consequences has to follow. Either it will be, because here it's not a question of like in other contracts, Unibros and all that, where it's a question of actually like delay damages. This is not one of those contracts. It's not that I've been delayed in performing, therefore I've incurred loss. Here it's a question of that there will be expectation loss, because like we know, contract principles are as if the contract has been performed. Contrary to tort, where it says you have to put back in the same position as you were before the injury happened. And that's what section 73, 74 also says so. So when we had claimed this about 300 and odd crores with regard to this entire, the arbitrators, after having held that there is a breach, has granted us, going back to 80 breach fall and all that, granted us 15% of that. Saying that let's have, and there's several, including Gambhir recalls AI 63, Calcutta 163, which says this is possible that you have a guess estimate really. And particularly in this kind of clauses. And particularly in this kind of contracts. Because kindly appreciate today, Contract performed, I would have got the whole thing. Contract not performed, one has to really guess what is the loss I've suffered. Now, my lord, it cannot be anyone's case that I have suffered no loss. Because, my lord, admitted position is there is some flaring up. That's an admitted position. They also come and say, by telling us that, no, look, you have actually flared less, is neither here nor there. Because I have the reserve of gas. 3.4 trillion I have, my lord, there. If you wanted, I would have given you more. And, my lord, I've given this example, my lord, also, my lord, sorry, my lord, I'm first quote, my lord, saying that if you agree to buy, I'm a car salesman, if you agree to buy 2 cars, and you do not buy, if I sell those 2 cars, doesn't mean I've not suffered any loss because I have other cars to sell. It would have been this additional 2 cars.
Provided there are other buyers.
Yes, correct. If there are no other buyers, because you would have been the buyer. What I'm saying, my lord, today, my lord, I have a contract with him to sell him 2 cars. I have more cars in my garage or, my lord, in my showroom. Now, those 2 cars which I had promised, he had promised me to buy from him, they get sold. They cannot then come and say, those 2 cars have been sold, therefore you haven't suffered any loss. It would have been the additional, those 2 would have been additional to what I already have. So, my lord, I hope, my lord, I'm saying your 2 would have happened and I would have also got 2. Just because, my lord, my profit has increased 10%, doesn't mean my profit would not have increased 30% with sale to you. And that is what, my lord, we are losing out on. It's not a question, my lord, that I made a profit at, because of course, my lord, the law also says you have to suffer loss for you to get loss, and you can't also profit there from someone else's breach. Even if it's a breach, you'll get nominal damages. But here, that's why I said, my lord, and that was our argument, saying that even if there is a little bit of flaring up, that's good enough to show that I'm suffering loss. Quite naturally, loss can't be measured in that way. Like today, my lord, those demurrage clauses, they're given there so that it is considered a genuine pre-estimate of damages in that sense. So the loss element, my lord, comes from that. And my lord, kindly see, my lord, when I show the award, with great respect, my lord, I say so, my lord, after all, my lord, the arbitral tribunal, my lord, has considered all this. Has considered breach, has considered whether damages should be given, what is the measure of damages. Now, my lord, the law, as I, my lord, understand, my lord, with my, my lord, understanding, 2 things, my lord, appear to be, my lord, in now, my lord, at present, my lord, the state is, my lord, that if it's a question of facts, the court should really not reappreciate facts. That's, my lord, what appears, my lord, to be. If it's an interpretation of a contract, again, the court should really, hands up, I'm not going to interfere. Unless one can show that this is an impossible,
but perverse.
Perversity, my lord, will come into that. If it's something which is plausible,
will not interfere.
No, court will not interfere. And, my lord, what is very important, I find, my lord, 37 courts, some of the cases, my lord, say, not Punjab Civil, the other one, 2025, 37 court, they say, again, my lord, I don't know, my lord, how it must be, my lord, the Honorable Supreme Court has said must be correct, my lord, that 37 court, in fact, sorry, my lord.
Yes.
Well, that 37 court is narrower than 34 court. Because they seem to be saying that 34 court is exercising its discretion, letting the award go. 37 court then will look at whether 34th court has exercised its discretion correctly or not.
That is my personal view also.
That's what the honorable. But one has to somewhere also has to look at the award. I'm not saying the award will not sustain the award, but that's what it says. 37 is even narrower.
Definitely not wider.
Not wider. Not correct. Absolutely. Yes.
Hey.
we in line with Malad, what has Malad fallen from court, 2025 6 Supreme Court cases, 757. And kindly come to paragraph Malad 40, 3. Sorry, Malad, may I just start Malad from paragraph 37, where Malad, they go into the question of Malad, interpretation of contract and what has fallen from court. I don't think Malad, there is any dispute or Malad, any issue Malad, with regard to that. 37 at page 776. 36, sorry, Malad. Division bench therefore held that the interpretation of the contractual terms given by the arbitral tribunal and accepted by the learned Singlage cannot be accepted as a plausible interpretation. Division bench observed that such interpretation is unreasonable and wholly implausible, and that the arbitral award is opposed to public policy of India, shocking the conscience. Therefore, the order of the learned Singlage arbitral award was set aside. We are afraid we cannot accept such sweeping conclusion reached by division bench. The plain language of clause 50 and 52 is not at all plausible one, not to speak of being the only possible interpretation, and therefore manifest intervening the arbitral award proceeding under section 37 of the 1996 Act, when the learned Singlage did not find justification at all to interfere with the award within the limited scope under 34 of the 1996 Act. Then Malad, kindly straight away come to paragraph 45, which is on page 778. In MMTC Limited, this court held that as far as section 34 is concerned, the position is well settled, that the court does not sit in appeal over an arbitral award and may infer on merits only on the limited ground provided under section 34 2b Roman 2, that is, if the award is against public policy in India. Even then, the interference would not entail a review on the merits of the dispute, but would be limited to situation where the findings of the arbitrary, capricious, or perverse, or when the conscience of the court is shocked, or when the illegality is not trivial, but goes to the root of the matter. An arbitral award may not be interfered with if the view taken by the arbitrator is possible view based on facts. As far as interference with an order under 34 by the court under 37 is concerned, it has been held that such interference under 37 cannot travel beyond the restrictions laid down in under section 34. In other words, court cannot take an independent assessment. Merits of the award must only ascertain the extent of power by the court under 34 has not exceeded the scope of the provision. I think, Malad, this is what Malad appears Malad to be Malad the now Malad, kindly come to. So this is Malad, as Malad we see it, Malad, the law, perhaps Malad, this is Malad what it stands. Then kindly come to Malad the agreement itself. At Malad page 231, this is Malad volume 2 of Malad the paper book. Malad, this is the contract. I hope Malad it's a legible copy, and I think Malad may have marked Malad from this volume itself. Compilation में mark করেছেন এখান থেকে mark করেছেন আমরা আলাদা একটা compilation উদ্দেশ্য করছি that the contract but I'm told there's also a compilation Malad of documents. I'm not sure Malad whether Malad has used Malad the compilation or Malad the then Malad, I'll show Malad from the compilation. If that's Malad, perhaps it will be in instrument Malad. Better. And a copy may also be Malad better. Malad, I don't know. Take it. Malad, kindly first come to clause 2 at page 3. Malad. Contract shall come into force from the date it is signed. Seller will use his best endeavor to lay down the pipeline to the buyer's premises within 45 days post signing of agreement and submission of the bank guarantee and clearance of right of undertaking, I think, from statutory authorities, thus enabling the seller to commence the work for the supply from the day all requisite permissions are received as applicable, and usage of CBM at the buyer's system. During the course, the buyer shall install a facility commission. Then next, this contract shall remain in force till 25 years. Subject to revision of terms and conditions, including price mentioned clause 10.1, seller reserves the right to review and may revise the terms and conditions contained therein, including price of gas after expiry of expiry period, defining clause 10.2. Then kindly take 5.1. Note 5.1 at page 4. Subject always to the availability of gas and seller's ability to supply the same. To the buyer, the seller agrees to sell the gas on firm basis to the buyer to be used by the buyer as fuel solely for its own business purposes, subject to the maximum of 35,000 only standard cubic meters per day and the total monthly of 9 lakh 10,000 only standard cubic meter per month, considering 26 working days in a month, hereinafter called as contracted quantity. Supply of gas shall be at an even flow rate spread over a period of 24 hours, and the buyer agrees to use at the same rate. However, supply of gas may be reduced due to technical production, interruption, or other reason. Then, in case the period of reduction in supply or stoppage in gas supply from the seller side lasts for continuous period of more than 3 months, then either party, buyer or seller, shall be free to terminate the contract by written notice of 15 days to the other party. This is the termination clause which is there. Subject to clause 8.3 and 9 in case the seller is ready and able to supply the contracted quantity of gas, but buyer purchases gas less than the K% of contracted quantity or on account of stoppage of supply by the seller as prescribed under clause 4.2 results in purchase of gas less than K%, then buyer shall have to pay to the seller for his quarterly minimum quantity, hereinafter termed as minimum guaranteed offtake, that is MGO, of K% contracted quantity. MGO will be applicable after 45 days from the commencement of supply of CBM gas, will be known as reading period. At the end of the reading period, buyer may amend the contracted quantity based on the actual consumption of CBM gas during such period. In case of stoppage or interruption or reduction in gas supply from the seller side, as mentioned in clause 5.1, 8.0 and other clauses, minimum guaranteed offtake will be reduced on pro rata basis, considering number of days in a quarter when the supply to the buyer was less than K% of the daily quantity mentioned in 5.1 due to reduction or stoppage of supply. The seller, for example, in a quarter, if the amount of gas supplied to the buyer is less than K% daily requirement mentioned in 5.1 for n days, reduction or stoppage of supply by the seller, minimum guaranteed for the will be as under. And MGO is given daily contracted quantity into number of days in quarter into K equal to 80%. Number of days in a quarter is 75 days. There was some controversy with regard to that. That was held in fact against us. The buyer undertakes to pay for such minimum guaranteed offtake. This is very important. The buyer undertakes to pay for such minimum guaranteed offtake or for actual quantity used during the quarter, whichever is higher. In the event of shortfall in supply of gas less than MGO level, and due to this buyer has to use alternate fuel, seller agrees. Now, kindly similar. I also have the corresponding liability. Seller agrees to compensate the buyer with the differential cost, which buyer had to actually incur over and above the agreed gas price with proof of purchase. Seller's liability in case of differential cost will be maximum to the agreed price of gas, and the differential cost will be calculated on basis of quarterly reconciliation. This will be settled through credit note by the seller to the buyer in subsequent invoices. Provided in any case, if there is any strike due to labor or other reason or at buyer and seller's work, such strike continues for more than 14 consecutive days. In such a case, provision related to MGO as mentioned clause 5.2 shall be applicable to either party for a period of such strike continues beyond 14 days. Then will not kindly look at clause 8.1. Buyers shall be entitled, that's on page 7. Buyers shall be entitled for partial shutdown for 30 days in each financial year. Buyer desiring to take partial shutdown will give 1 week prior notice to the seller, intimating for the proposed partial shutdown number of days of shutdown. Shutdown period at the rate mentioned above cannot be accumulated, and if not available, treated as lapse. During such partial shutdown, the provisions relating to the minimum guaranteed offtake in clause 5.2 shall be applied. New DCQ shall, during the partial shutdown days, will be half of the agreed DCQ, and MGO during partial shutdown period will calculate in accordance with so revised DCQ. However, the scheduled shutdown from seller side shall be 15 days in a financial year. Shutdown from seller shall be termed as full shutdown and will be intimated to buyer 1 week prior to the proposed date of shutdown. However, during such full shutdown, provision related to the MGO in clause 5.2 shall not be applicable. Then buyer shall in 8.2 about any defects in gas supply calling for complete partial shutdown, not really relevant. Then kindly see clause 9. There's a force measure clause. Ten is price of gas. Then 11.1 is on the question of billing and payment. The seller, sees 11.1, seller shall issue and raise invoice to the buyer, considering the actual consumption of the buyer as per para A, B, and C and given below, with supporting documents either by email, fax, hand delivered, or couriered. Then ABC, reconciliation, all that goes on. Then kindly see after that, in addition to above, seller shall issue and raise quarterly invoice to the buyer, considering the actual consumption of buyer for that quarter, or minimum guaranteed offtake. As per clause number 5.2, whichever is higher, buyer shall make the balance payment in full within 7 working days of receipt of such invoice. Then in case there is any dispute regarding billing, buyer shall not be withhold payment after making full payment of such invoice. And so then kindly take 11.5, which is the security deposit I was talking about, because the arbitrators have interpreted this as well. The buyer shall submit a revolving confirmed bank guarantee, which will always remain in place for the amount of the contracted quantity for 1 month. In case of default in payment, seller shall have the right to encash in part or in full bank guarantee to recover all its dues at any point of time. In case there is a shortfall, the buyer will have to pay the same to the seller immediately on demand. Format of the bank guarantee is attached. Then BG amount equal to daily contracted quantity of gas, clause number 5.1 into 31 days into contracted gas price, including VAT. And then termination is there at clause 15. 5.1 to देखिए. But 15, this contract, page 11, this contract shall stand automatically terminated on April 30, 2034. Seller has unrestricted right to deduct all its all pending claims from the bank guarantee submitted by the buyer, notwithstanding anything contrary contained therein. In the event gas supply of the buyer is suspended due to non-payment of dues under this contract, seller shall have the right to terminate this contract effective from the date of suspension. Then the arbitration is before that and all that. So just 2 or 3 comments on this. One, it is a structured agreement negotiated between the parties to look after certain performance related issues so far as the contract is concerned, with a minimum guaranteed offtake clause, and which says whichever is higher you're supposed to give. Contract is for 25 years from 2011 up to 25 years up to 2034. Oh, it's from 2009. Now, there has been now an interpretation of the contract by the learned arbitrators. But before that, let's just kindly see a few more documents. Is it in the file? Lord, kindly look at document of 18th April 2014, which is my lord at page. Oh, sorry, my lord, I have to page 74.
Dated?
Document dated April 18, 2014. Volume 1. And just before this, my lord, from 2011 to 2014, they had also, and that was one of our cases also, which has been recorded, they had also paid MGO amount. So the contractual clause was being worked out. So whenever, my lord, there was a fall in the minimum guaranteed, my lord, offtake, they, my lord, paid that amount. So it was, my lord, kindly, my lord, look at, this is our letter on April 18. You have furnished a bank guarantee of rupees 93 lakhs 18,000 against your contracted quantity of CBM in respect of contract number May 11, 2011. Please be informed that the above referred bank guarantee dated June 4, 2012 will expire on May 31, 2014. You are hereby requested to renew the existing bank guarantee in the enclosed format on or before May 15, 2014 for smooth supply of CPM gas to your plant. Now, my lord, this gets replied on, my lord, April 22nd, 2014. That is it. April 22nd, 2014, they write to us, with reference to the above contract, caption, subject matter, and further subsequent discussion, you are hereby requested to waive off the MGO clause mentioned in your clause 5.2 with immediate effect to enable us to continue the gas sales and purchase agreement, further solicit your cooperation and immediate response. Now, very important. After this date, 22nd April 2014, when they gave us this, on 25th April 2014, they had entered into another gas supply agreement. That will find at page 3219. Volume 23. Questions? '86.
SR, you said. SR.
SR. Sorry, may I actually show from? No, let's show from. 3219, 3218. Volume 23. 22. Sorry, 22. Question 83 থেকে. So again, we are really not required to go into such detail, but I'm just showing, my lord, what was the purpose, my lord, and how, my lord, this came about. Kindly just look at, my lord, question 83. Okay. 3218. Shown the document, Exhibit 7, which is at page 72 of the statement of claim, was a request letter. This is what I showed. Request letter issued by the respondent to the claimant to waive MGO clause. Sorry, my lord, has that, my lord, question 83. Then 84, please look at question 52 and now answer question 52. Exhibit E7, which is at page 72 of the SOC, which was a letter issued by the respondent to the claimant, was not an objection letter to the MGO clause. It was a request letter issued by the respondent to the claimant to waive MGO clause. Please look at question number 62, which was asked on the last question. Are you in a position to answer this? Yes, please answer. Date of agreement which the respondent has entered into with SR is 25th April 2014. What would be your answer to question number 64, for which you also wanted to check the records? Supply of gas was affected by SR from 25th April 2014. Then are you in a position to answer question number 65 today? I'm just going to show that series as well, otherwise, my lord. And if yes, please answer. Commercial details in relation to a business dealing with SR is bound by confidentiality because I'm not in a position to disclose the same. This is, my lord, the agreement, whether, my lord, they will. On the 89, on the last occasion, answer to question 69, 70 of said you wanted to refer to your legal team before you produce the agreement. Respondent entered into with SR on 25th April for supply of CBM gas to the respondent. Will you produce this agreement today? Independent agreement SR is bound by mutual terms and condition entered into between respondent and SR, including confidential. Therefore, I shall not be in a position to produce the same agreement, said agreement. And if one just looks at not his previous answers from which we came, question at page 3212, kindly similar from question 51. I'm showing you exhibit 7, which is at page 72, same document, of the statement of claim. Sorry, 50. One, would I be correct in saying that the first time any objection was raised with regard to MGO was on 22nd April 2014, which is a letter from you in reply to the letter of the claimant dated 18th April 2014, calling for renewal of bank guarantee, that is after nearly 3 years of the working of the agreement. I have to check my records before answering the said question. And he is one of the managing director, right? Mr. Periwal. I am showing you exhibit 7, which is at page 72 of the statement of claim. Would this be the letter by which the respondent for the first time raised an objection to an MGO clause? I have already stated that with regard to my reply to raising objection for the first time, I have to check my records before answering the same question. Kindly check the records and tell on the next question. Yes. Would I be correct in saying that the agreement of 11 May 2011 requires the respondent to make provision for dual fuel intake arrangement? I would like to look at additional document, go through the same. Yes, the same is mentioned in clause 4.2 of the agreement. Does that mean that you will have to maintain arrangement to heating the furnace by using CBM gas or any other alternate fuel source? The alternate fuel was to be used as an emergency standby fuel option in case of non-supply of gas by the claimant. Now, these words emergency standby, which you used in your previous answer, do not appear in the agreement. Am I correct? The same is evident. Perusal of portion of clause 5.2, whereas in the event of shortfall in supply of gas less than MGO level, due to this, buyer has to use alternate fuel. Seller agrees to compensate. This is the clause, my lord, I showed. Seller agrees to compensate the buyer with the differential cost which buyer had actually incurred over and above agreed gas price with proof of it. Then, my lord, kindly see. Do you know a company called SR Oil and Gas Exploration Production Limited? I do not recall the complete name, and I would like to understand whether it is CPM gas supply in addition to claimant in Durgapur Raniganj, which you question. Is there a CBM gas supply in addition to the claimant in Durgapur Raniganj built by the name of SR Oil? Currently, there is a gas supply in addition to claimant with name of SR, though I do not recall the full name. And what connection does the respondent have with SR, the full name of whom you do not remember? Company is currently supplying CBM gas to a Durgapur work. and you do not remember the full name of the company which you're saying. What I understand that in the recent past there has been change to the name of company, therefore I'm not sure regarding. Has this SR been supplying gas to the respondent from 1st April 2014? I do not remember the exact date of commencement of gas supply of this. What is the date of agreement with respondent as entering to with SR? I have to check my records. Do you remember the month, the year? I remember the agreement was entered during 2014. If I tell you that the agreement was entered on 25th April 2014 with supply of gas effective from 1st April 2014, would you disagree? I have to check the records. And there's the same CBM gas which has been supplied by the claimant, which is also subject matter of supply and agreement with SR. SR is supplying CBM gas to our works. However, there is difference with regard to calorific values answered, same purpose. See, I'm pressing the division line here. Well, so my submission is that this was really the reason behind why they wanted the waiver and they terminated. Now, after that letter of 22nd April, we'll find that the whole series of correspondence to and fro saying that we said increase it by ₹5 if you want the waiver. They say no, we were not going to increase. You please reduce the price. This went on. In the end, there was no agreement. And why I mention this? Because before the first court, this was their argument. The stress, the main argument was saying that no, MGO clause stands waived. And therefore, you could not have made any claim. I mean, I'm not saying they're not entitled to argue whatever they want to argue, because here I find the stress or the argument really is on the basis that look, they could not have suffered any damages because of the fact that they were making profit. And how did this figure of 28 point something come about? That's what the argument here seems to be.
I think
Now, kindly.
Mr. Mitra made it clear that ground we have not pressed before the division bench.
I'm also saying that.
Mr. Mitra has only argued the point of damages.
I'm also saying that.
That is the point.
That's exactly. I'm just giving a statement of fact in the sense this was not argued before the first court. Something else was argued before the first court. Now here, something else is being argued. That's all I'm saying. I'm not saying that legally you can't do that. Of course you can do that. Everyone will think whichever is to be argued best will be. Now, kindly come to the correspondence, maybe just a few, 2 or 3 more correspondence, and then I'll come to the award. Just to show where the page 76 of volume 1. Huh? Page 76.
Yes.
Page 76, will find, just continuing from what I was showing before.
Yes.
75 was the request, and then 76. Dear sir, this is with reference to a letter dated April 2014, wherein you have requested for revision of MGO, that is from present 80% to nil. And the aforesaid context, we wish to inform you that in accordance with the agreement, any revision changes in terms and conditions are possible during the renewal of existing contract. However, in view of our long-standing business relations, and hence as a special case, we may consider a request only if in clause 10 of the contract there will be an increase in price of ₹5 on the current price of ₹21 excluding VAT. Further, the increase of ₹5 per SCM will be applicable additionally over and above a price increase in future. That is from such. Thus, we request kindly confirm as a concern above in writing. Then, my lord, they say kindly come to next page 77. Malad, we went into a lot of interpretation, Malad, both before Malad, the learned arbitrators as well as Malad, before the first court. Just kindly look at the first sentence, Malad, which I found always Malad, quite amusing on their part. We are grateful for your acceptance to complete waiver of MGO. We sincerely believe the same would be effective from 1st July 2014. Then Malad, kindly look at in your letter under reference, dated 24th April, you have also requested for increase in price by ₹5 per SCM. This increase is quite steep and not in accordance with the present market scenario. Should appreciate that all at present price gas is around 17 per SCM and proposed increase will bring up price to ₹26, which is not commercially ethically viable. Hence, we would request you not to press for such unreasonable increase which will affect our business adversely. However, looking after long-standing relations, again being requested to review a decision with withdrawal of MGO clause unconditionally or else becoming very difficult to carry out business in compliance with the said agreement. In view thereof, kind cooperation, immediate response are highly solicited.
না ওরা ওখানে ছিল বোধহয় 21, ওরা দিচ্ছিল বোধহয় 21, কারেন্ট প্রাইস অফ 21 ছিল না, এটা বলছে জেনারেল মার্কেট, এটা বলার চেষ্টা করছি। কন্ট্রাক্ট প্রাইস ছিল 21।
And very interesting, Malad, would have also Malad remembered the date, Malad. By this time, they had already entered into the 25th April 2014, Malad. Already agreement was entered into. So this Malad went back and forth. Malad, there was no agreement, and that's what Malad the arbitrators have also held, and Malad the first court also held that there was no agreement. And in 78, Malad, of course, they made a counter offer. Then Malad, until Malad the termination, which is Malad 7 July at page 114. I hope it's read up. 114, Malad, that's the. I hope, Malad, it's legible because this copy is Malad totally. You have a better copy.
Oh, no.
I'm sorry, Malad, I'm so sorry. Why don't you stay? No, Malad, this is not. Kindly do not even try reading it. I'm sorry, Malad, I don't know how Malad this. Malad, I will Malad get a typed out copy, Malad, of this and show it. I don't think Malad should just strain my lords. এটা কোথাও বেটার আছে কোথাও কপি? হ্যাঁ, টাইপ কপি দিয়েছো? Malad, I'm told Malad there's a no. Malad 118, I'll just check Malad whether 118 is a no, I don't know.
No. That's different, something different. 118 is your letter.
My letter, greatest. Sorry, no. I'm so sorry, Malad. I just wanted to show the termination. We'll have it typed out.
You don't want us to read your termination letter?
We have conceded to it. Termination is whatever arbitrator has said, single bench has said, we have not argued against that.
Malad, we'll just Malad show that Malad later. Now kindly come back. Then Malad, may I just take Malad to the award itself? Huh?
I was doing a compilation.
Malad, in fact, sorry, Malad, since Malad is there, just Malad one. Malad, I had mentioned Malad that Malad at one. This is Malad page 120, 121. Malad, you'll see Malad. I have mentioned Malad that civil suit Malad which they filed Malad in the High Court Malad, wanting to really stop us Malad from encashing the bank guarantees. In that Malad, they had mentioned this. This submission was made at page 121. So where is it? Where is it? We look for balance. Lord, at page 121, just kindly look at the second paragraph. However, the matter comes a rest since the plaintiff, Lord, has that, Lord, in the middle. Since the plaintiff has decided to terminate the agreement. This is an order, my lord, of July 8th, 2014. Mr. Sansad submits fuel supply be restored and continued till 15 July 2014 to enable his client to find another supplier, which is, my lord, on the face of it is not correct. Because there is no answer, with great respect, there is no answer to the termination. Termination on the face of it is a wrongful or illegal termination. And that is why, my lord, I also, my lord, appreciate what they, my lord, tried to do in the first court, my lord. Why they wanted to argue that if it's been waived, MGO clause, then, my lord, there's no termination. Then the termination has no consequence, because that is the reason, my lord, why it was terminated. So if the MGO clause, my lord, they could have been successful in showing that the MGO clause stood waived by reason of this correspondence, then, my lord, really the heart of the matter, or the meat of the matter would have gone. So, my lord, now, my lord, that is the situation. So, my lord, if there is a termination, then what is the consequence? Really, my lord, the arbitrators thought it one way. The arbitrators really thought that a erring, breach, or a party who is in breach should not go scot-free. And I agree, my lord, it is a guessed estimate in that sense. To say, very well, let us give you 15% of the overall which you claim, which is a higher sum, you get this. Now, my lord, kindly come to, my lord, the award. Compile. My lord, I am told, my lord, compilation.
It's in the compilation.
It's in the I have the paper book one. Page 87, it's in the
If you continue till recess, we can release your senior and others here.
Lord, Mr. Mukherjee, my lord, has the next matter. We also have the next matter, my lord. So,
Oh, I see.
Lord, that Vodafone matter, my lord, which
We understand, but will
My only problem, my lord, is that, my lord, I won't be available, my lord, after my lord recess.
I see.
So, my lord, kindly keep it next Monday then, my lord. This can, your lordships in the flow, my lord. You can
The
also.
only thing, my lord, in the next matter, my lord, kindly takes the orders, my lord, because, my lord, we are, my lord, suffering. My lord.
आज के तो होवे ना
हमारा होना जाएगा fix that.
We can take it up today. I mean, after Mr. Banerjee concludes.
Lord, I am, my lord, then he'll do it, my lord, your lordship.
Oh, you are not, he is Mr.
I'm not
Mukherjee.
here, my lord. I'm amazed, my lord. I spoke to my learned friend senior, my lord, that I cannot be available.
Next Monday,
We
next
agree.
Monday.
But I don't know, my lord, whether Mr. Mitra has given any consent or not, but my lord, only thing is, my lord, kindly see, my lord, from June onwards, my lord, directions have been given. My lord, time has been taken from June, my lord.
You're enjoying an interim order.
We are not enjoying any interim
course you're
order.
enjoying.
Money is being deposited in the bank, which we are entitled.
Yes, very well, Mr. Rajudi. Mr. Mukherjee is in difficulty
Malad,
after
kindly see,
recess.
the last two orders, the same submission was made. I can't also, I have people also.
Next Monday.
No obliged.
So no, next Monday this should be the first matter under appeal from hearing. Tai to ache. Mr. Rajudi will be taken up next Monday.
That will be recorded. They are paying for time at least once.
লিখে নাও লিখে নাও এটা হচ্ছে 4 আর 5 4 5 6 আলাদা করে করো on the request made on behalf of the appellant let this matter stand adjourned and be listed again on সামনে সোমবারের দিকে, retaining its position. করে same order 456.
Only thing is, my lord, on that day, my lord, I hope, my lord, the matter is heard. Because, my lord, I
Why
have
are you
people
telling
coming down.
us? We are there.
My lord, your lordship has
Mr.
directed
Mukherjee has some difficulty. What
And
can we do?
I had indicated also.
All right.
I have, my lord, instructing advocates coming down from Delhi every time.
আমাদের হয়েছে successfully resisted.
You can continue with your gas.
That to CBM.
With hopefully
It
with
doesn't
some,
smell good.
but hopefully my lord, with some solid effect. My lord, otherwise everything in the air, my lord, will not, my lord, help. But in the award, but in the award, but I'm not saying, my lord, that the court should only go, my lord, on the basis of, my lord, who were the learned arbitrators. My submission is, my lord, that the award, when you read the award, it appears that the arbitrators have applied them. That's the only, my lord, statement I want to make so far as the award is concerned, because I think that makes a huge difference.
A lot of emphasis was put by Mr. Mitro on non-consideration of material evidence.
Yes, my lord.
He said repeatedly that even if the tribunal had considered and said, no, not reliable, we will not rely, one thing, but not considering at all comes within those.
Yes, my lord,
to address that.
Yes, my lord, I'll just straight away, my lord, just answer that and then I'll deal with it in detail. My lord, these are, my lord, the Chrysal and Care report. I'll show, my lord, I don't know how it is relevant. In fact, in their written notes also, it also has to be argued in a way where it is made the most important document. It is not. Chrysal and Care, my lord, are first of all, my lord, third-party reports, which was done, my lord, at the time when, my lord, there was a IPO, my lord, coming up. It was introduced, my lord, by one of his employees. When I say his, my lord, one of the company's employees. And in the notes also, when I show, no extra special stress on that. On the contrary, my lord, with great respect, my lord, what goes against them is their own admission with a chart to show there was a there was flaring up. They ran their case by saying, oh, look, there was less flaring up. After 2014, there was less flaring up. Our submission was implicit in that is the fact there is flaring up. If you live by the, for lack of better word, sword, you also have to face that. So that is evidence of, on your own admission, that is evidence of loss being suffered. It is not a question of exactly how much was being flared up. Therefore, you will get that quantity. I'm sorry, that's not the question. I would have produced more. And that's why I said, my lord, we would have got this additional profit from you, which is a minimum 900,000, my lord, whatever that, my lord, minimum guaranteed amount is there. And for which you would have had to pay us. So the Chrysal Care report, with great respect, and they also use it, and they also, my lord, gave a statement. My lord, we have to mandatorily file a statement, my lord, before the Ministry of, my lord, Hydrocarbon and Energy, my lord, one of the government, where, my lord, it is also shown how much is being flared up. And annual report also, my lord, says what is, my lord, being flared up. So argument was, even if there's a little, whatever flaring up is there, that is good enough for loss, to say that sustained loss. And therefore you fall back on the minimum guaranteed. Instead of getting the whole thing, I've got, my lord, a 15% of that. And that is, my lord, the main point. They're saying you have not taken care of, the arbitrators have not taken. I'll show that paragraph also, my lord, where there is a reference to the hydrocarbon energy report.
Yes, Mr. Ben.
Well, kindly come to paragraph in the award, page 25, of the convenience compilation. One issue they raised, saying that there was breach on our part by delaying the supply of gas. So that kindly look at the finding.
Paragraph?
Paragraph 17, page 25, paragraph 17. In cross-examination to question number 268, Mr. Ashish Beriwala, respondent's main witness, was asked whether there was any delay in gas supply by the claimant. To that, the witness replied that the gas supply was as per agreement. His further answer to question number 217, cross-examination, also confirms that the pipeline was laid within 45 days of clearance of ROUs from the statutory authority. Same is the answer in cross-examination, question number 276. Then, paragraph 19. Considering the above evidence on record, this tribunal is unable to hold there is any admission of delay by the claimant in gas supply. Well known that to operate as admission, evidence has taken as a whole, not bits and pieces. Tribunals cannot hold. Faltered in discharging its control obligation, which may endeavor to supply gas to respond 45 days from date of. So, then, this is one of the aspects. Then, B is pricing of gas. Though there is no argument made, so maybe I'll just show some of the findings on this. 35 will kindly come to. I'm missing 50. 50 is the final. The 35. We need to show page 33, paragraph 35.
Just out of curiosity, did you appear before the tribunal?
Yes.
You appeared.
It's a very, very contested and very good match.
And your opponent was Mr. Obruji's Mitra.
Yes. It was a good match. Really, this is one of the matters where you really enjoy arguing when there's a breach of contract and
correct.
Quite a difficult. Wasn't an easy arbitration at all.
No, sure, and with gas. Yes. Yes. 35.
35. No, I'm sorry. Just with that. In fact, this was not here. He did well. He actually what he did, and I wanted to adopt this in one of my other arguments. He did part 1, part 2, part 3, part 4, and took all the topics and gave arguments and the documents, which was quite helpful. Quite helpful, to the learned arbiter as well as to me.
Venue was Calcutta. Venue?
Yes. This 35, this arbitral proceeding has another significant facet which has a direct impact on gas pricing. Challenging the clauses of the same, GSPA, including the clause for gas price and minimum guarantee clause, Mr. Saurabh Tripathi, one of the employees of the respondent, and he filed a proceeding against the claimant before the Competition Commission of India, entirely on the ground that the claimant, enjoying a dominant position in 2011 in the matter of supply of CBM gas, abused his position and coerced the respondent to accept one-sided and burdensome terms, including gas price under the GSPA. About gas price, similar contention was raised by the respondent, paragraphs 13A, 13B, 13C of his SOD. In the complaint before CCI, a prayer was made to declare GSPA contrary to Section 4 of the Competition Act. After a prolonged and contested hearing, and by detailed order dated 16 February 2017, CCI held that no case of contravention of Section 4(1) is made out against the OP, the claimant hearing. Appeal against the said order of CCI was filed by Sri Saurabh Tripathi before the Competition Appellate Tribunal, compiled by an order dated 15/5/2017, rejected the said appeal entirely on the ground that the appeal was not mentionable. Then a writ petition was filed before the Delhi High Court by Saurabh Tripathi, being WP's Sansad, challenging the finding of CCI. Writ petition was also dismissed by Delhi High Court, details admin at 10th October 2019. Both Malal, I have some occasion to show it because it also talks about one of the damages. Learned counsel for the claimant, 39, relied on various findings reached both in CCI and that of High Court. Learned counsel responded course of his submission before this tribunal, accepted that the findings reached by CCI and the High Court on the same, this is very important, on the same GSPR are binding on this tribunal. In fact, in the course of detailed written submission, respondent has not ever urged that findings reached by CCI and the High Court are not binding on this tribunal. Then 14, the course of cross-examination, Mr. Beriwala, director of the respondent company, even though feigned ignorance about the proceedings of CCI, at the same time admitted to have made a statement before CCI in the connected proceedings. And Malad 41, Malad, is the narration, Malad, with regard to Malad, unfair pricing, Malad, whatever Malad they had. Then kindly come to paragraph Malad 50. Yeah. I'm sorry, Malad. Yes, 50 Malad is the ultimate finding, but before that, Malad, may I just show 44 and 45? Those respondents' counsel objected on my other side to production of the orders of CCI and its appellate forum before this tribunal. Courts of his final argument did not argue or spell out anything about his objection, either orally or in his written notes. Rather, the learned counsel for the respondent proceeded on the basis finding reached in this forum the same GSP are binding on this tribunal. In 45 from the aforesaid order of Delhi High Court dated 10th October 2019, appears that Delhi High Court found that the petitioner Mr. Saurabh Tripathi was put up by SRMB in view of the disputes that have arisen between SRMB and GECI. Again, in para 65 of his judgment, Delhi High Court held present proceedings are an abuse of the process of law. Thereby, the petitioner Saurabh Tripathi has been put up by SRMB to pursue the present proceedings. It appears that about gas pricing, SRMB agitated the matter before the Ministry of Petroleum and Natural Gas, but the matter was closed by the government after seeking a reply from GECI. 46. Then Malad 47, Malad, he relied on Reliance Natural Resources, which was a completely different Malad fact situation, and Malad question of law. That Malad is dealt with. Then 50. Sorry, not 50. 50. 58. That decision Malad is distinguished. Then 58. As such, this tribunal does not find any merit in the contention of respondent about gas pricing, and the said contention therefore rejected. Now, Malad 59 onwards, Malad, MGO clause. Now, this was what was Malad the subject matter of Malad argument before the first court. I'll just try and Malad, it's not been argued here. Because, again, Malad, we don't know Malad what will be argued again, not argued. So, Malad, but this was Malad really the main focus when Malad the first court was hearing this matter. Kindly Malad come to 59. This issue has figured very prominently in the dispute between the parties with the minimum guaranteed offtake clause. 5.2 deals with MGO provision, applicable 45 days. We can skip over 61 records that 9 lakh 10. Then kindly come to 65. And 66 is very important. In the SOD, the respondent in paragraph 13C pleaded that it was compelled by the claimant to make payment of minimum guaranteed amount, and the respondent has also alleged in paragraph 18 of the SOD that the MGO clause is unfair and the claimant abused its dominant position to make the respondent agree to the same. And in paragraph 19, the respondent has said that MGO clause is null and void, contradictory and self-defeating. Virtually similar contentions were raised against the same MGO clause before CCI and the High Court of Delhi, and in both the fora, the aforesaid contentions against MGO clause were rejected, as would appear from discussion made hereinafter. Then 66. However, the respondent admitted, this is what I was saying, admitted to have paid in terms of the MGO clause in paragraph 13C and paragraph 20 of the SOD. Claimant also stated invoices raised on 13/3/2012 for the period from 13/12/2011 to 12/3/2012 on account of MGO for a sum of 4,74,000 was paid by respondent. This is admitted by RW1 in cross-examination, answered question number 96 and answered question number 100. Then Malad will kindly come to, I'm just skipping over this. Paragraph 71 is very important. 70 and 71. Actually, my lord, sorry, my lord, I need to read my lord 70, 71, 72. According to the claimant, the respondent is liable to pay the MGO charges. MGO charges to the claimant for the entire duration of GSPA, that is up to 30th April 2034. It is virtually common case that CBM gas and its production, being a natural process, cannot be stored. That is common case. It has to be distributed to the customers for consumption, or it has to be flared up. In paragraph 67 of the judgment of CCI, also it has been found that CBM gas, if not used, has to be flared up. In SOD, the respondent pleaded that it provided bank guarantee in terms of GSPA. First bank guarantee was dated 20th October 2011 for rupees 1,75,00,000, and the second bank guarantee was given for a sum of 93 lakhs, which is dated 4 June. Respondent also pleaded that both the bank guarantee intended to secure MGO, clause 11.5. Case of the claimant is still in the first quarter of 2014. Respondent went on receiving gas supply from claimant without demur, paid on the MGO clause as stated above. Then, my lord, kindly take paragraph 8. Then, my lord, the discussion on this entire, the letters being exchanged, and kindly come to paragraph 85, page 47. This tribunal has therefore to decide the controversy whether MGO clause has been waived or not. Reading the exchange of correspondence between the parties as referred to above, this tribunal finds that the first proposal to waive the MGO clause comes from respondent with its letter dated 22nd April. You know, I've seen this letter, I showed that. To that, the claimant's response with its letter dated 24th April 2014 was that it may consider the request of the respondent as a special case, provided the respondent agreed to enhancement of price of gas by rupees 5 per SCM. In that letter, the claimant wanted the respondent to confirm their consent to the above in writing. In reply to that, the respondent did not accept the proposal of the claimant and wanted the claimant to withdraw the MGO clause unconditionally and make it clear that otherwise it was becoming very difficult for them to carry on their business in compliance with the agreement. Respondent reiterated the same proposal of another letter in 19 May for waiver of MGO, reduction of base current market price of CBM. Claimant immediately on 23rd May informed respondents it was not acceptable to them. Considering its long-standing relation with respondents, goodwill, consider reduction MGO from 80% to 75%. Then 89, my lord, that is also discussed. Then, my lord, kindly come to 91 at 93. Very important. In view of the aforesaid discussion, well, I'm not showing the detailed findings because they're all findings, interpreting those letters. I'm not showing that because it has also not been stressed here. In view of the aforesaid discussion based on the materials and record, this tribunal cannot come to the conclusion that MGO clause has been waived by the claimant or that it stands abrogated in view of the modification of the agreement as alleged by the. This is the finding which the and on that same finding also 96 before. 96 also part of that finding, para 96. At this stage, the respondent came with a counter proposal of waiving the MGO clause with a hike in gas price. This was never accepted by the claimant, rather it clearly rejected it with its letter date 2nd June 2014 referred to above. Then 103. In view of the aforesaid discussion materials of the record, this tribunal holds GSPA was never modified, nor was the MGO clause abrogated, waived as alleged by the respondent. This condition respondent cannot be accepted. On the rationale of MGO clause, 104 and 105, the learned counsel for the claimant cited several judgments which are considered hereinafter. We cited these judgments. Reliance was first placed on the judgment of Supreme Court in the case of Bihar State Electricity Board, Patna, and others versus Green Rubber Industry and others. In that case, Supreme Court was considering the question of minimum guarantee charges under Electricity Supply Act 1948. Court held that the agreement with the stipulation of minimum guarantee charges cannot be held ultra vires on the ground that it is incompatible with the statute. In that case, High Court took the view, board having disconnected the supply, it was not open to the board to charge minimum guarantee charges during the period of disconnection. But reversing the High Court decision, the Supreme Court held that even during the period of disconnection, consumers' liability to pay minimum guarantee charges must be held to them. The learned counsel for the claimant very much relied on this finding. Then, my lord, next 106, again, my lord, rational minimum guarantee charge in Bihar United States, utilizing the judgment of Calcutta High Court. Then, kindly see, my lord, that quoted portion, which was, my lord, approved, my lord, by the Honorable Supreme Court. It was really based on the principle that every consumer's installation involved the licensee in certain amount of capital expenditure in plant and mains on which he was to have a reasonable return. He would get a return when the energy was actually consumed in the shape of payment of energy consumed. When no such energy was consumed by the consumer or a very small amount was consumed in a longer period, licensee was allowed to charge minimum charges by his license. But those minimum charges were really interest on his capital outlay incurred for the particular. This, my lord, I think very accurately represents, my lord, the rationale of why you have a minimum guarantee of it. And this is
63 Calcutta. Who was the judge?
But
Anyway,
my lord,
just as a matter of interest.
I only remember, my lord, this is not convenient, my lord. I'm just very, the rationale is, my lord, quite
Yes, very clear,
and
concise, precise. Justice P.B. Mukherjee, was he there then? No.
I took 50s.
50s.
I don't know, I'll just.
Anyway, will you continue or some other day?
Not some other day, my lord. I also, my lord, have opposing Mr. Mukherjee, my lord, in
Tell
next
us when?
Lord, next Monday, my lord.
Next Monday. Friday, you are not here.
I'm not there. I'm so sorry, my lord.
Dekho. Mr. Banerjee, Learned senior advocate representing the respondent, begins his argument but does not conclude. Paragraph as requested by Mr. Banerjee, list this matter once again on Shamne Sombare date though, retaining its position.
I'm very grateful. For judgment, my lord. The moment.
Next Monday would have
এই মানডে রাখছে না আচ্ছা 8 I'm grateful.
Second floor, second floor order, item number 7.
And for the appellant, I am being led by Mr. Jantu Mitra. My lord makes it not to do that. Yes.
Item number 8.
ছিল ফার্স্ট কলে ছিল আমি দেখেছি আসলে আরেকটা থার্ড কল করো একটা
Item number 10. Number 11. 12. 13. 14. 15.
The Lordship, I am for the appellant. Lord, the respondent is not here.
ক্রস ওভার
16.
My lord, I'm
17.
My lord, I am from the appellate side. My senior is engaged in another court. Short passing. 16 and 17.
18. 19. 20.
Number 20, I'm led by Mr. Shoraji Dasgupta. He's always speaking for short passing.
Item number 8.
কি করা যায় বলো তো জানি যে এইসব এখন আস্তে আস্তে আসছে একটু দূরে থাকো
I'm sorry, my lord. Item 21, it's my appeal.
20 is gone, passed over. Twice passed over. Twice passed over. Third time it would have been dismissed, but
Saved.
what happened? Suddenly everybody has gone home.
The other side is not here. Chilo. Mate, please, my lord. Well, may I start, my lord? My lord, on the last three occasions, my lord, I've already dealt with a majority of the claims. Only, my lord, will take my supplementary notes. That's the only thing I have left. I won't take much.
Who's on your other side?
Mr. Miss Ghosh was appearing and taking notes for her senior also, my lord. Miss Orijita Ghosh. She's been appearing throughout. I don't see her. In any event, my lord, whatever I'm submitting are all reflected in my notes.
Correct.
So I can, my lord, at least make my oral submission so far, if it pleases to my lord.
Yes, you complete.
Yes. Okay.
Supplementary নাকি দিয়েছে?
Supplementary notes on argument, my lord, will kindly take. That's all I have left. If my lord has
the second page. The first page I had already taken, my lord, 2. That was a point of non-arbitrability that I had taken in respect of claims 5 and 8. 5 and 8, my lord, are those claims relating to, my lord, the joint welding work, which I had already taken, my lord, 2. That my primary point was it is contrary to the terms of the contract. And also the arbitrator has passed the award and gone on a finding which is admittedly, as per the arbitrator himself, without any evidence. There was no evidence to show that my client had instructed the contractor to do XYZ works, that is mostly in respect of spot welding. The arbitrator finds that there is no such evidence, but arbitrator says, since there is no contrary evidence to show I had not, that is a negative on a negative. There cannot be any finding on the basis of a negative finding as to evidence. So on spot welding, my lord, it's an admitted fact there is no evidence before the arbitrator to come to a finding that my client had instructed the contractor to do spot welding. Despite that, the arbitrator says the onus is on me to show that I had not. And on that basis, since I have no further evidence to back my case up, the arbitrator grants the award on the amount that is relating to spot welding of each and every intersection of the RCC cage, my lord, the reinforcement cage. So that also, my lord, in my humble submission, claim 8, which is a substantial claim, that is one of the larger claims, because all the claims are, my lord, minuscule amounts, but they add up at the end of the day. Claim 8 is contrary to the contract and passed without evidence. Now, I had also relied upon my supplementary note to add an additional point as to non-arbitrability. The contract specifically provides that it is the joint director of my client, my lord, who is the final authority in respect of extra claims that are made by the parties. Admitted cases, the joint director had rendered a finding by writing to the contractor that these claims are inadmissible and rejected the same. Thereafter, it was not open for the arbitrator to reopen the issue, and in fact, the award is silent on that. The arbitrator does not go into the jurisdiction of the arbitrator to deal with these claims which have been expressly rejected by the joint director. There is a section 16 which was initially filed by my client. That order is also there where the arbitrator holds no, the arbitration may proceed. It will be considered with the main matter on merits, this point as to non-arbitrability. Thereafter, this point is not decided. I have referred to the section 16 order as well, or in my notes. That's at page 672 to 678 of volume 5. It's a short order that my client had suffered at the section 16 stage. Thereafter, the award, there is no reflection of this. Under section 34, my lord, I am entitled to raise this point after a section 16 is dismissed. This is the only avenue I have, my lord, to my lord, get my grievances redressed. Now, my lord, that's insofar as claims. My lord, may I just take, my lord, to the section 16 order once? I think that would be proper, my lord. Volume 5, if my lord has 672, page 672 onwards. Malor will take it from me. It's a 7-page order. The entirety is in essence, Malor, the recording of submissions of the parties. Only Malor will kindly take the reasoning is only one. That is one paragraph, page 678, paragraph 6. This is the totality of the reasoning. This is a section 16 order, which, Malor, by virtue of the section 34, I am entitled to re-agitate these points again before Malor. Sorry. My lord, paragraph 6, if my lord has. However, judging the plea of the respondent on from the merit angle, it is seen that clause 12 of the contract leaves only two things of any altered, addition, or substituted workout of the jurisdiction of arbitration in terms of clause 25. These two things are A, proportion of time extended for any altered, additional, or substituted work. B, determination of the rates on analysis for any altered, additional, or substituted work. But the respondent has failed to establish that the claims relate to the claims 5 and 8 relate to any of these two things only. My lord, here the arbitrator, in essence, what he does prior to this, my lord, it is only, my lord, observations as to the contentions of the parties, all the other paragraphs. The only finding is this one paragraph where the arbitrator holds that proportion of time to be extended, that is not my case, for any altered, additional or substituted work, determination of rates on analysis of any altered, additional or substituted works. The points which are covered under clause 12, they don't relate to claim numbers 5 and 8, which have been challenged by my client under section 16. Clause 12 and clause 25 are also quoted. Lord can have a look at those two clauses. That's clause 25, which the arbitrator refers to. That's at page 674. That's quoted. The two clauses which have been referred to, 674, if my lord has. Above clause 25 is a portion of the quoted clause 12. My lord will kindly have the underlined portion. In the event of any dispute regarding the rates determined on analysis from any altered, additional or substituted work under this clause, the decision of the joint director shall be binding. This is what I am also relying upon. This clause says the joint director has the right to determine the rates in respect of any altered work to be done under the contract. Thereafter, clause 25, except where otherwise provided in the contract, all questions, disputes relating to the meaning of specifications, drawings, so and so, mentioned in as to the quality of workmanship of the material used on the works, as other questions, claims, rights, matters, things whatsoever in any way arising out of or to the contract, design, drawing, specification, estimate, instructions, orders or conditions or otherwise concerning the works or the execution or failure to execute the same, whether arising during the progress of the work or after completion or abandonment thereof, shall be referred to the sole arbitration. What my client was relying upon and what I rely upon today is the first line of this clause 25, except where otherwise provided in the contract. This has to be read with the preceding clause, which says in respect of any altered work, the rates that are payable to the contractor is the decision of the joint director only, and his decision shall be final and binding upon the parties. Therefore, once the joint director comes to that finding, and that letter is on record, I've referred to that in my note as well, which I showed my lord on the last occasion. The joint director has specifically rejected their claims on account of claims 5 and 8, that is spot welding and extra boring work. So once, and those two, my lord, will kindly bear in mind, the arbitrator at page 678 says that claims 5 and 8 do not relate to any altered work. My lord, expressly that is contrary to the material on record, inasmuch as, my lord, the arbitrator specific, or rather claims 5 and 8 relate to extra work, which is an altered work. The contractor says the work under the contract is X. I do X plus 1 in the form of spot welding. That is the subject matter of claim 8. Despite that, the arbitrator holds no, section 16 not maintainable. The binding clause 12, which provides the joint director's decision is final and binding, is given a go by because the arbitrator holds this does not relate to any altered work. This is expressly contrary to the or rather contrary to the material on record. That's their claim. A plain reading of their claim shows that this is the case.
Have you placed the order under challenge? No.
Well, the section 16 order. Well,
34.
Yes, Malord, on the first occasion, Malord had read the order once. I can
No,
place
no,
it
no,
again.
no. Learned judge of this court or?
Learned judge of this court, Malord. This court.
We'll just once go through the order.
Yes, Malord. Yes. I'll just indicate the page number. That's at 799 of volume 6. Volume 6. $799 if my lord has. My lord, here while reading the order, my lord, will kindly I'll rely upon, my lord, paragraphs 15 and 16 for the point of law that I've tried to argue, that the learned judge viewed the award from an incorrect angle. She did not view it from a pre-2015 Amendment Act angle. Paragraph 15 and 16 specifically refer to the 2015 Amendment Act. The discussion really starts from para 9, page 805. Before that, it's the submissions bullet. Judgment belongs. Malad, just I won't place the order again. Malad will kindly take note of two things. In the order, specific reference is made, and Malad, the page numbers are 805, 811, and 813, my lord, we'll find specific references to section 34(2) capital A. This provision was inserted into the Arbitration Act after the 2015 amendment. The AP in which this judgment was, my lord, delivered is of 2010. The award is of 2010. Everything prior to the 2015 Amendment Act. On the first occasion, my lord, one judgment. This is a point of law that I'm arguing, my lord, which will, if my lord is with me on that, my lord, then the merits of the award need not be gone into at all. My lord, will you kindly take the judgment I had relied upon before the erstwhile bench, my lord, 2022 4 SCC 206. My lord, this, my lord, will kindly take para 12. I had placed this. May I just again show this paragraph once? My lord, specific finding of the Honorable Supreme Court that the scope of a section 34 application post-amendment is much more strict, or rather interference is much more narrowed. The scope of interference is much narrowed after the 2015 Amendment Act. The learned single judge, my lord, has not considered this aspect and has gone, perhaps, my lord, for some reason or the other, my lord, has gone on the basis that this is a post-amendment section 34 and has viewed the award from that angle. Because, my lord, one of my substantive grounds of challenge, and which is not really dealt with in the order, my lord, is that the award is contrary to contract. Once it is contrary to contract, and I can show a provision of the contract which denies the claimant of an entitled sum which has been awarded by the arbitrator, the award has to go. Pre-2015. Post-2015, the language of 28(3) has changed to say that the arbitrator shall only consider the terms of the contract and usages. Prior to 2015, the Arbitration Act specifically said, 28(3) said, the arbitrator shall decide on the basis of the terms of the contract. And that was the line of decisions of the Honorable Supreme Court. I will be citing one of such instances, my lord, where the Supreme Court has held, as soon as the arbitrator goes contrary to the contract, he's traveling into an arena without jurisdiction. Because the arbitrator is a creature of contract. That is the sum and substance. The learned single judge, like the arbitrator, goes on evidence and says that there was sufficient evidence before the arbitrator to award such claims by way of the measurement books and so on and so forth. That is, in my humble submission, irrelevant once I show an express bar in the contract. And I have shown, my lord, at least, my lord, to my limited, my lord, so far as I hope I have been able to convince, my lord, as to claim 158 specific provisions of the contract prohibiting such claims. Specific provisions of the contract. Incorrect placement of files, specific contractual clause saying he is not entitled to payment for any incorrectly placed files. Similarly, spot welding, the rates under the contract are, as a whole, are inclusive of all rates, including extra work. So once I show these clauses, my lord, perhaps, my lord, if the learned single judge had viewed the award from that angle and perspective, perhaps, my lord, this order would not have come. So, my lord, only as to this, since I am on this point of law and since my lord is on the impugned order, my lord, will kindly take Kochi cricket. My lord has seen this. My lord, 2018 4 SCC 287. Paragraph 39, my lord has seen this judgment a number of times. 2018, no. Kochi cricket. 2018. My lord, paragraph 39. হ্যাঁ ঠিক আছে বলে দিচ্ছি আমি প্লেস করে বুঝিয়ে my lord, paragraph 39 if my lord will take. Paragraph 39, may I just quickly place? Section 26, this is section 26 of the Amending Act, therefore bifurcates proceedings as has been stated above with a great degree of clarity into two sets of proceedings, arbitral proceedings themselves and court proceedings in relation thereto. The reason why the first part of section 26 is couched in the negative form is only to state that the Amendment Act will apply even to arbitral proceedings commenced before the amendment if the parties otherwise agree. If the first part of section 26 were couched in a positive language, like the second part, it would have been necessary to add a proviso stating that the Amendment Act would apply even to arbitral proceedings commenced before the amendment if the parties agree. In either case, the intention of the legislature remains the same. remains the same. The negative form conveying exactly what could have been stated positively with the necessary proviso. Obviously, arbitral proceedings having been subsumed in the first part cannot reappear in the second part, and the expression in relation to arbitral proceedings would therefore apply only to court proceedings which relate to the arbitral proceeding. Well, the next sentence is very crucial. The scheme of section 26 is thus clear. The Amendment Act is prospective in nature and will apply to those arbitral proceedings that are commenced as understood by section 21 of the Principal Act on or after the Amendment Act, and to court proceedings which have commenced on or after the Amendment Act came into force. Specific finding, it's settled law today. My arbitration was prior, my section 34 was prior. Everything happened prior to the 2015 amendment. The Arbitration Act, as applicable to this case, has to be prior to amendment, as it stood prior to the 2015 amendment. And why is this important? Muller will kindly take page 339 of this very same judgment. There's a footnote, Muller, where another decision of the Honorable Supreme Court is quoted. Page 339. Will give me 1 second. 339, Muller will kindly have the footnote. Footnote number 55. These amendments have the effect as stated in HRD Corporation versus Gale India of limiting the grounds of challenge to the awards as follows. This is relating to the 2015 Amendment Act again. Here, Muller will kindly take para 18 quoted of HRD Corporation. In fact, the same Law Commission report as has amended section 28 and section 34 so as to narrow the grounds of challenge available under the Act. The judgment in ONGC saw pipes has been expressly done away with. So has the judgment in ONGC Western Gecko, so and so. I only draw Muller's attention to this because ONGC saw pipes is a judgment I will be relying upon before Muller. This was a judgment which was sought to be done away with by legislation, by amending the Act. And that has been recognized by the Honorable Supreme Court. And Muller will kindly note, the Honorable Supreme Court also notes in HRD Corporation, specifically notes that section 28 has also been narrowed. The scope of interference. Section 28 is also amended by the 2015 Act. Now, in this context, Muller, I will be relying upon the judgments of ONGC saw pipes as well as associated builders. That I will, Muller, at the end, after I complete on the merits of the claims, I'll just indicate. Now, Muller will kindly come back to my note. This is only on the point of law, Muller, that the learned judge went wrong while viewing the award. Muller, if Muller will kindly come back to my notes. Muller, I've shown the section 16 order, which I am entitled to again re-agitate at the section 34 stage. Muller, section 16 specifically does not consider that claim 5 and 8 relate to alteration of the work, therefore are expressly made non-arbitrable because of the first first sentence of the arbitration clause, which says except as otherwise provided in the contract. This has to be read with clause 12, which says the joint director's decision is final and the joint director has rejected these two claims. Therefore, no further arbitration can be had on that. Now, Muller will kindly take claims 6 and 7 in my supplementary note. 6 and 7, Muller, both relate to extra concreting work and dismantling of concrete done by the claimant in relation to the installation of RCC board piles. Muller, that's page 2 of my note. Muller, the award, Muller, deals with these two claims in a summary manner that Muller will find the relevant portions of the award at page 706 and 707 of the award, volume 5. If Muller will just glance through it, Muller, I think it won't take much time. 706 if Muller has. Muller, claim number 6, volume 5. my lord, has claim 5. 706, my lord will take claim 6, the heading. My lord, the second unnumbered paragraph, my lord will see respondent referred to R47 with a prayer dated so and so, claimant addressed to the respondent stating that extra concreting work as per claim 6. This is the subject matter of claim 6, extra concreting work. In 1000 piles done already, the respondent also states that this claim was settled between the parties, made on due consideration of the work. The claimant stipulation as per Annexure E is that 2/3 of the work was paid, not the total. Hence the claim. My lord will kindly see the reasoning. The claim is accepted in view of the respondent not putting up any evidence showing full payment. My categoric case is the claim has been settled between the parties, and I've adduced a letter to that effect. That my lord will find, I specifically refer to, my lord has seen this letter R47, and the second unnumbered paragraph R47 is referred to the first sentence. R47 with a prayer dated 1st July 2003. This my lord will have at page 470 of volume 4. 470 of volume 4. This is his prayer for, my lord, extra concreting work that has been considered. The arbitrator states that this has been relied upon, and thereafter talks about my stand. My stand is that after this letter, the claim had been settled and no further amount was due or payable by my client. Because my lord will kindly take a note of the date on which this prayer was made, 1st July 2003. 1st July 2003. Thereafter, the contract was completed much later, and no claim was raised thereafter. If we had not responded to this or made full payment, they would have at least written an additional letter saying you still haven't made payment, you haven't considered my prayer. That's not the fact. And instead, my client has specifically taken a plea in their statement of defense. Mullah will kindly make a note of the page number only, which is reflected in the award. Page 376 at volume 3, where I deal with the 6th claim. Here, my client's specific stand is that after this letter was made, it was mutually settled between the parties that no further claim would be made. The arbitrator does not consider this. The arbitrator only says that since I have not adduced any further evidence, I will award the claim. It does not discuss on what basis this claim is made, or rather whether the claimant has discharged his burden to prove the claim. He just simply stated on the ground that this prayer was made, and thereafter I have not laid any evidence to show full payment. I am allowing this additional 1/3 payment for the extra concreting work. That's the totality. It's an unreasoned award completely. It's not based on any evidence at all. Mullah will kindly now take claim 7. That's if Mullah comes back to volume 5. Claim 7, Mullah will see. This is extra dismantling of concrete work. The claimant state that for execution, that's at page 707. Claimants state that for execution of the pile cap, they dismantle the concrete above the cutoff as was stipulated. Since the extra concrete was executed beyond the stipulated height, the concrete above the stipulated height had to be dismantled. Mullah will kindly see here the arbitrator goes on the third last paragraph, Mullah, the sentence starting with, or rather, may I just place it in full, Mullah? The next paragraph, the respondent states that payment for dismantling of pile has been duly made and no additional payment is due. The quantity is sum as that of quantity of additional concrete M2 done in the pile as stated in paragraph mark 27 against claim number 6. This is a supplementary item of work accepted in the second supplementary tender. Quantity is similar to that of claim number 6. Respondent has already been paid for the quantity of 288. Therefore, the balance is awarded. Again, not discussing my counter, which is again along the same lines, where I state that the matter has been settled after this prayer was made. Again, my lord, reference is made to this page 470. After this prayer was made, it has been considered and settled. No further claim was due or payable. And the contractor has not written after 1st July 2003 claiming this amount, has never written after that. Therefore, it has been settled and no further amount is due or payable. Now, that's essentially on 6 and 7. My 2 points are non-consideration of my stand in the statement of defense and unreasoned award. It does not go into any reasons for awarding these sums. No discussion as to whether this work was actually done, this work for the balance payment that is due, whether it was actually done, whether they had written to us contemporaneously making such claims, nothing of that sort. Only this amount was the work done as per the claimant's own case. This is the amount paid. Balance amount is due and payable. Paid. That's it. Now, my lord, will kindly quickly come to my lord, page 3 of my notes. Claim numbers 9 and 11. My lord, this is very interesting, my lord. Claim 9 relates to extra earthwork done by the claimant. Claim 11 is unpaid shuttering work done by the claimant. Both the claims, my lord, the arbitrator comes to findings that no documentary evidence is available in support of the claim. Specific finding of the arbitrator. My lord, I've quoted that portion of the award. My lord, will kindly have a look at it. I need not trouble, my lord, with the award again. Specific finding, the claimant has not referred to any documentary evidence in support of this claim. After this, what survives? That, my lord, will find at page 712 of volume 5. But, my lord, I've quoted it. The respondent's position is in tune with the measurements recorded in MB number 76 and MB number 42 and 66. This is reasonable. However, in the 47th sitting on 5th March 2009, Shri S.K. Bishwash, counsel for the claimant, pointed out about the saving in the shoring work. True saving has been achieved in the shoring by this process of additional earthwork by the claimant. Total amount of saving is 9,500 rupees. That is thereafter awarded. That, my lord, will find page 712. The total amount awarded is 9,785 rupees. Perhaps, my lord, not a large sum, but, my lord, after that one finding, my lord, all these sums, all of these claims once add up, my lord, they add up to a substantial sum. Specific finding, no evidence. Thereafter, arbitrator on his own presumption finds that some saving has been made by the respondent due to some work allegedly done by the claimant. Therefore, let's award this claim. That's the totality of the finding. My lord, the arbitrator has also ignored, my lord, my client's specific stand as to claim number 11, that no shuttering work was done. Claim number 11 relates to shuttering work allegedly done by the claimant in addition to what was required to be done. My client specifically takes the stand that no such shuttering work was done. That reference, my lord, page 378 is my stand in the statement of defense. Specifically stated, my stand is there. Now, my lord, will kindly see the observations of the arbitrator in granting claim 11. Specific finding is no details for the area claimed is given, no location is referred to. Then statement of the respondent also does not reflect the ground reality, as excavation was for a group of piles of varying numbers as indicated in serial number 30 of SOD/CC by the respondent themselves. In rejoinder to SOD and CC, the claimant has failed to provide any documentary evidence and or detailed calculation relating to the area and the location of shuttering in support of the claim. However, the circumstantial evidence establishes the claim in an indirect way. What is the substantial or the circumstantial evidence? Nothing. It's only a specific finding that there is no documentary evidence. There is no reference to the positioning of the piles. Nothing is there. However, an arbitrator just records that there are circumstantial evidence not referring to what, and thereafter granting the claim. This, my lord, will again find the reference, the award, my lord, will find 714 is the portion I've quoted. 714 is the finding as to claim 11. My lord, after this, the claim could not have been, after these findings, specific findings, no claim could have been awarded. Now, claim number 13, very quickly, my lord. The claim relates to cost of vertical load by hydraulics in relation to 1.5 times the design load. the award fails to appreciate the stand of the appellant at para 34 of the statement of defense, wherein it specifically contended that the vertical load test was carried out in respect of load of pile being 90 metric ton, which is in the permissible range as per the contractual clause. The claimant stated that the pile load tested was in excess of 100 metric ton. The learned arbitrator only held that the claimant's position has been found to be reasonable by me. 716 is that portion of the award. If my lord has claim 13, that starts at 715. Here, my lord, the contractual provisions are also quoted. I've relied upon this, upon the contractual provisions also in my note. Here again, my stand is it is contrary to the contract. The award is contrary to the contract. Page 715, if my lord has once of volume 5. The claimant states, if my lord has 715, my lord, claim number 13, the claimant states that item number 12, as per the item number 12 of the specified price schedule of the contract agreement stipulates as follows. Vertical load test by hydraulic jack stroke pile with 1.5 the designed load is as per IS specifications on single pile with testing between 60. Mallory, kindly note these two words, 60 and 100 metric ton. That cross refers to metric tons. 60 and 100 is the permissible load in respect of which this vertical test is to be made. Vertical load test has to be made within this range of 60 to 100 metric tons in respect of each pile. However, the next paragraph, however, as per the instruction of the respondent, they had to test the piles for higher loads, whereas the item work stipulates routine testing of piles for a load between 60 to 100. They had to conduct load tests with loads varying between 113 to 186. The extra loading and unloading cost is payable to them. Amounts claimed are so and so, so and so. Specific stand of my client is thereafter recorded at page 716. In the instant case, the design load of pile is 90 metric ton and therefore falls within the 60 and 100 metric ton as specified in the specified price schedule of the probable items with approximate quantities of work. Hence, the claim is not maintainable and rejected. Two contrary stands taken on pleadings. What was the arbitrator supposed to do? If I may ask myself this question, he had to analyze whose stand is proved by way of evidence. There must have been evidence led to prove one stand or the other. The arbitrator does not do so. We kindly see the next sentence. The claimant's position has been found to be reasonable by me. Documentary evidence is referred to as C107 Annexure A. This exhibit is a letter from the claimant addressed to the respondent dated 16 September 2004. The rate of rupees 135 per metric ton is also reasonable. It's a simple letter that is issued by the claimant to the respondent. It does not prove the fact that higher load was tested. In ignorance of my specific stand taken in my statement of defense, where I say that it was 90 and not 186 as alleged by the claimant, the arbitrator does not even discuss that at all. No discussion on cross-examination, no discussion as to evidence, only reference to one documentary evidence, that is a letter written by the claimant to the respondent. That is all. Nothing further. The arbitrator holds that this claim is found to be reasonable on his account. Lord, ex facie, my lord, without evidence, and ex facie without reasons. Without reasons. Now, my lord, last point on merits, my lord. This is the counterclaim of the respondent. If my lord kindly has page 5 of my note, the counterclaim of the respondent, or rather the appellant before my lord. Counterclaim relates to loss suffered due to delay in execution of the work. Here, my lord will find that it is my client's specific case that the contract was to be completed and the work was to be completed within 12 months from the date of formal work order. That, my lord, the formal work order is at page 70. I am not bothering, my lord, with that. It's there. The date is mentioned in my note. 3rd October 2003. Therefore, the work had to be completed by 22nd May 2004 within time. They have not done so. The claimant never abided by the terms of the contract and delayed performance of the contract. It was completed sometime around 2000. My lord, I'm sorry. My lord, my mistake. My lord, the work was to be completed by 3rd October 2003. It was actually completed on 22nd May 2004. So a delay of about a year in completion. On that ground, my lord, I am entitled to, my lord, I have referred to several letters that my lord will find at page 6. There's several letters, page 72, 416, 417, 419, 420, 421. These are all letters issued by my client to the contractor, intimating them of the delay in progress of work and of the loss being suffered by my client. If my lord has volume 1 for a second, my lord. Volume 1 tag. Page 72 if my lord has. My lord will find this is a letter issued by the contractor, my lord, seeking an extension of time with reference to so and so, intimating of your acceptance of our tender, execute a formal agreement within 7 days from the date of receipt of the letter. We hereby inform you that the same could not be done for reasons beyond our control. The claimant's own letter admitting delay in performance. 420 Specifically, these letters and documentary evidence have been ignored, my lord, by the arbitrator. That's my stand. Thereafter, my lord. And thereafter, my lord, the other letters are 416 onwards of volume 3. Onwards. My lord will find these are letters of the respondent appellant 416 onwards. My lord will kindly take the last paragraph. In this connection, it is further informed that neither work activities nor representatives from your end were found at the site for the last 7 days. It is needless to mention that your earnest, there must be a portion missing, my lord. The work and maintained progress is very much needed. You are requested to confirm the revised date of load test and trial of the piles immediately. And thereafter, my lord, several other letters. 417, my lord, again, is a contractor, my lord, writing to my client. My lord, here specifically, they admit that there has been delay. They try to justify it. If my lord has 417. My lord, second paragraph, if my lord takes, unfortunately, though we have made an all-out effort to execute the work at the fastest speed, our endeavor to do the same is being frustrated by a group of antisocial elements, about more than 20 in number, manner so and so, so and so. They try to justify the delay. Thereafter, my lord, 419 is again another letter issued by me. Similarly, 420. Each of these letters, my lord, I issued them a letter saying that you are not carrying out work within the speed or rather with the manpower and expediency that is required. They write back saying, yes, we are not. However, for this XYZ reasons, antisocial elements, so and so, so and so. So delay is an admitted fact. There is no doubt that there has been delay in completion of the work. But the contractual provision I have quoted in my notes, specifically page 6 of my note, clause 2 of the contract, page 47, volume 1 is the reference. There specifically, my lord, I have quoted that time is the essence of the contract. They are to complete within time. And my lord, claim number 14, my lord will kindly see the arbitrator has come to a specific finding that there has been repeated failures. If my lord has once page 720, that's a part of the award, 720. Because the arbitrator had also, or rather the claimant had also made a claim on account of delay. My lord, will my lord kindly have the top of that page? 720. The top of the page. Delay due to piecemeal issue of drawing, unhappy law and order situation surely cannot be attributed to the claimant. Similarly, for the repeated failure to adhere to the work programs as revealed through many contemporaneous letters, the claimant cannot absolve themselves of their responsibility. The director engineering in his adjudication in terms of clause 25 of the contract allowed time up to 30th April 2004 with an imposition or without imposition of clause 2, but the order of the director engineering dated 23rd March 2004 in no way a verdict on imposition of clause 2. It merely stated that its operation for a certain period, and add to these the fact that there is no price variation clause for the extended period of contract agreement in view of the prayer of the claimant regarding claim 14 is not acceptable and the award is nil. Here the claimant had claimed damages on account of prolongation of contract. That was rejected. The arbitrator comes to a finding that both were responsible. There was alleged piecemeal issuance of drawings from my end, and admittedly there was default on the part of the claimant as well. The arbitrator does not go into the question of apportionment of these delays, merely states both are liable. I find no claim is due and payable, and on that basis my counterclaim is also thereafter rejected. Well, that is referred to in my note. The counterclaim is rejected, page 728. I've quoted it. Malad will kindly take page 7 of my note. I've quoted the relevant portion. I would now refer to my comment award on claim number 14 in serial number so and so, wherein I have made both the respondent and claimant responsible for delay of 7 months 14 days in execution of the work after a detailed consideration of all evidence. Now, there is no such detailed consideration in my view, Malad. These letters which I have referred to, Malad, do not find reference in the award and have not been considered. These letters which I have referred to in page 6. And on that basis, Malad will find the arbitrator has rejected my counterclaim on account of delay. So, Malad, that's essentially on the claims. That's all I have to say on the claims. So, counterclaim, there is non-consideration of vital evidence. In respect of the other claims, Malad, either there is a prohibitory clause in the contract which I have referred to for the particular claims where there are, and even otherwise, there's vital evidence or a stand of my client which has not been considered by the arbitrator. So the award has to go, Malad. It has to go and it can't be piecemeal. The entire thing has to be looked at differently. Now, the learned single judge, Malad, will find from the order has not looked at the award in the lens that she has supposed to. Malad, in this regard, Malad, two judgments which were binding upon the learned single judge as on the date on which the award was passed and when the section 34 was decided, Malad, they have not been considered. Malad, on the ground of prohibitory clauses of contract, Malad, will kindly take 2007 volume 2 SCC 453. Ramanath. Paragraphs 12 and 18 are the clauses that, or rather the paragraphs I rely upon. Malad, we kindly take paragraphs 12 and 18. Malad, will kindly take para 12 and 18. Para 12 and 18. Very quickly, Malad. Clause C provides that extensions have been granted by reason of delay enumerated in clause A, which were beyond the control of the contractor or on account of delays on the part of the employer specified in clause B. The contractor is not entitled to make any claim either for compensation or otherwise arising in whatsoever manner as a result of such extensions. Now, Malad, after enumerating certain delays, clause 8 of clause A specifically mentions delay on account of any other cause beyond the control of the contractor. The causes for delay specified in clause A thus necessarily thus encompass all delays over which the contractor has no control. This will necessarily include any delays attributable to the employer or any delay for which both the employer and the contractor are responsible. The contract thus provides that if there is any delay attributable either to the contractor or the employer or to both, the contractor seeks and obtains extension of time for execution of the execution on that account, he will not be entitled to claim any compensation of any nature on the ground of such delay, in addition to extension of time obtained by him. Therefore, the claims for compensation as consequence of delay in claim 24 of the so-and-so are barred by clause 11C. We are fortified in this view by several decisions of this honorable of this court. We may refer to two of them: Associated Engineering versus Government of Andhra Pradesh. This court was concerned in an appeal related to similar claims based on delays in execution. Here, my lord, finally it is held that these claims could not have been awarded by the arbitrator. Clause paragraph 18, if my lord will kindly directly come to paragraph 18 at page 459. In spite of having held that both were responsible for the delay and having noticed the arguments on clause 11C of the general conditions of contract, the arbitrator proceeded to award damages on the ground of delay on reasoning that the contractor is entitled to compensation unless the contractor establishes that the contractor has consented to accept such extension of time alone in satisfaction of his claim for delay. As rightly held by the High Court, which decision we have affirmed while considering questions 1, clause 111C of the general conditions of contract is a clear bar to any claim for compensation for delay in respect of which extensions have been sought and obtained. Clause 11C amounts to specific consent by the contractor to accept extension of time alone in satisfaction of his claims for delay and not to claim any compensation. In view of the clear bar against award of damages on account of delay, the arbitrator clearly exceeded his jurisdiction in awarding damages, ignoring clause 11C. Associated Engineering is thereafter closed. If I may only place, my lord, paragraph 24, which is quoted, the arbitrator cannot act arbitrarily, irrationally, capriciously, or independently of the contract. His sole function is to arbitrate the terms of the contract. He has no power apart from which the parties give him under the contract. If he has traveled outside the bounds of the contract, he has acted without jurisdiction. Settled law, especially applicable prior to 2015. Post 2015, the law has changed substantially. Now, my lord, on the general grounds of challenge, Associated Builders. Associated Builders has been referred to by the learned single judge. My lord, we kindly consider two paragraphs. My lord, this is often cited, my lord. I won't place the entirety of it. Only paragraphs 31 and 42.3. 31, my lord, deals with perversity. Para 31 at page 75. May I please? Page 75. The third juristic principle is that a decision which is perverse or so irrational that no reasonable person would have arrived at the same is important and requires a degree of explanation. It is settled law that where a finding is based on no evidence, I have shown, my lord, at least two claims which specifically the arbitrator finds that there is no evidence. And for the others, my lord, I have shown how there could not have been any evidence. For example, spot welding. Arbitrator himself says there is no evidence saying that I had instructed the contractor to do spot welding, but there is no contrary evidence to show that I did not. That is still a finding without evidence. In a vacuum of evidence, my lord, that finding has come. That is ex facie perverse, when, my lord, para 31 comes in. Now, Roman 2, an arbitral tribunal takes into account something irrelevant to the decision which it arrives, and thereafter 3 ignores vital evidence in arriving at its decision. Such decision would necessarily be perverse. Now, my lord, will kindly take 42.3. Here, my lord, patent illegality is dealt with. 42.3. That's at page 81. patent illegality 42.3. Equally, the third subhead of patent illegality is really a contravention of section 28.3 as it stood prior to 2015, my lord. This is the language. In all cases, the arbitral tribunal shall decide in accordance with the terms of the contract and shall take into account the usages of the trade applicable to such transactions. Specific provision of law saying that the arbitrator is bound to decide in accordance with the terms of the contract, completely ignored by the arbitrator. The clauses of the contract are completely clear. There is no ambiguity at all. The learned judge also, my lord, with due respect, my lord, has ignored this fact, has not gone into this my lord, issue at all. Now, my lord, last judgment, my lord, ONGC saw pipes, my lord, which has been done away with by the 2015 amendment, but is applicable to our case. Para 28 and 40. My lord, may I just place very quickly? Para 28 at page 726. This is really the judgment on the basis of which the award had to be viewed. From this discussion, para 28, if my lord has, from this discussion, it would be clear that the phrase public policy of India is not required to be given a narrower meaning. As stated earlier, the said term is susceptible of narrower or wider meaning depending on the object and purpose of the legislation. Hence, the award which is passed in contravention of section 24, 28 or 31, 28, my lord will kindly note, section 28 is also a point. In addition to section 34, section 13(5) of the Act also provides that constitution of the arbitral tribunal could also be challenged by the party. Similarly, section 16 provides that a party agreed by the decision of the arbitral tribunal, which provides that a party, agreed by the decision of the arbitral tribunal with regards to its jurisdiction could challenge such award, arbitral award under section 34. In any case, it is for the Parliament to provide for limited or wider jurisdiction of the court where the award is challenged. But in such cases, there is no reason to give a narrower meaning to public policy as contended by learned senior counsel, Mr. So-and-so. In our view, wider meaning is required to be given to prevent frustration of the legislation and justice. Now, my lord will kindly come to paragraph 40. 40. Page 731. It cannot be disputed for construction of the contract. It is settled law that the intention of the parties is to be gathered from the words used in the agreement. If the words are unambiguous and are used after full understanding of their meaning by experts, it would be difficult to gather their intention different from the language used in the agreement. If upon reading of the document as a whole, it can be fairly deduced from the words actually used that the parties had agreed on a particular term, there is nothing in law which prevents them from setting up that term. Further, in construing the contract, the court must look at the words used in the contract unless they are such that one may suspect that they do not convey the intention correctly. If the words are clear, there is very little the court can do about it. My specific case here is the words are explicitly clear. If the contract prohibits a claim on account of incorrect placement of piles, the words cannot be construed to mean something differently. The arbitrator has completely ignored this fact, has committed a violation of section 28(3), therefore has committed a patent illegality, which requires to be set aside. The learned judge, while discussing the award, has gone into evidence. Undoubtedly, there was evidence before the arbitrator. But once there is a contractual bar, and once I can show that vital evidence was ignored by the arbitrator, no matter how much evidence to the contrary is led by any party, it cannot circumvent or obviate that contractual bar. Therefore, my lord, the arbitral award, my lord, in my humble submission is patently illegal, perverse, and contrary to contract. My lord, it's liable to be set aside. My lord, that's all.
Yes. Why don't you want to start now? You have 15 to 20 minutes to go today. You are there. Start. Is your microphone switched on? হ্যাঁ। কৌশিক, আমি বলেছিলাম মাইক্রোফোনটা পাল্টাবার জন্য। আমি যদি কালকে দেখি এটা পাল্টানো হয়নি, আমি জানি না কে রেসপন্সিবল, খুব মুশকিলে পড়বে, বলে দিও। Yes. Yes.
My learned friend's contention was that the new amendment restricts the court from going into evidence. But my lord, if we go through the section 34 order, we will see that even though there have been references to the 2015 Act, but the learned single judge has painstakingly gone into the details which have been recorded and has even considered the evidences. On this point, my lord, there's the evidence that is based on measurement books. It is not like that once I have created the piles, only after that they have inspected. There's inspection at every stage. Once I excavate, once I put in the cage work, and then even before concreting, at every stage measurement is taken by the engineer in charge. So that is all recorded, all that is recorded in the measurement book. And that forms a annexure to the award itself. However, that was not placed before the learned single judge, but while considering, since the learned single judge was considering the evidence, that was later on filed before the learned court, and the learned court had gone into the details. So it is not like that evidence was not considered and it was heard in a restricted sense as in terms of the 2015 Act. That is with respect to the first contention, that it was dealt with as if it was an award after 2015 regarding that contention. My lord, I would want to place one clause from the contract that is at page 88 of volume 1. It has been argued that the learned arbitrator has traveled beyond the scope of the contract. And it has been argued that since the term defective piles were used, it is an admission that it was a mistake on my part, and if there's any additional work done due to my mistake, then the cost has to be borne by us. With respect to this point, my lord, I would want to place this one paragraph which starts with defective piles. If the tilt and shift are more than the permissible limit, the concrete is of poor quality, the load test is unsatisfactory, or there is any defect which in the opinion of the engineer in charge will affect the strength of the life of the pile. My lord, there is no, it has not been contended. This is not the case. What has happened is I have put in the piles according to the drawing provided by me, and it has been inspected at every stage by the engineer in charge. It was not the case that I have deviated from the drawing. It was just that after the pile caps were visible, it was they had come to the conclusion that some may not have been required, or some additional piles are required. So that is not a defect in terms of this defective piles, and hence it is not an excluded work. There's also a clause relating to joint inspection, which is at page 90, my lord. Even all this inspection at page 89, record of boring of piles, from all this, it will be evident that each stage it was inspected. It was not it was not like that I had deviated from the drawings. And as on today, they are actually supporting the structure. Those piles are supporting the structure. They are taking the benefit of whatever support that extra piles are now giving to that structure. My lord, and as far as the section 34 application is concerned, if we go through the grounds, we will see that the grounds relate to claims 5 and 8 only. At this point, coming before the section 37 court, they are now agitating all the other claims.
কেন জন্য চ্যালেঞ্জ করেন জানি না এনিওয়ে একটা লয়ের উপর প্রত্যেকটা কি যাচ্ছে নিজেও জানি 34 যদি চ্যালেঞ্জ আছে yes restricted to 5 and 8
Yes, the grounds are completely restricted to 5 and 8.
Where's the 34 petition?
34 petition starts from page 1 of volume 1 and the grounds are at page 17. Grounds 1, 3, 4, 5, 6, 7. It's all restricted to claims 5 and 8.
Not really. They've attacked all claims, but very, very vague general grounds.
My lord, specific claims are with respect to claims 5 and 8 only.
After having been influenced or otherwise, was the implement of word. কিছুই নেই সত্যি সত্যি কিছু নেই বিয়ন্ড দ্য প্লিডিংস তো অনেক কিছু বলে গেল আমাদের কাছে ছেলেটা So what do you say to the argument that 5 and 8 were accepted matters in the sense that if it related to measurement or the rate applicable, joint director's decision was final?
My lord, that has been dealt with. Even the section 16 order has not been challenged, I believe, in the section 37 application.
No.
Page 672, my lord, is the order of the section 16 application.
That order we saw, yes.
Which specifically
Yes, the learned arbitrator did not allow that plea.
My lord.
5 and 8 are not arbitrable. But they have in the 34 petition, they have taken the same point which they were entitled to.
My lord.
How do you answer that? In matters of rates for altered or the adjective chilo works, substituted, varied, altered works, the decision of the joint director will be final.
My
So,
lord, in my humble submission, this does not relate to a dispute regarding the rates. It's regarding the work, additional work, not the rate. They are disputing that they are entitled to pay anything. They are disputing that they are not entitled to pay anything because this was an error on my part, which is not the case. That is why it will not come under the accepted matters, because it does not relate to a dispute relating to rates. They have never disputed the rates. They are just saying they are not entitled to, they are not liable to pay anything. My lord, with respect to the rest of the claims, may I place the case on Monday?
देखो, Mr. Mukhopadhyay, learned counsel representing the appellants, appellant actor, yes, concludes his opening submission. Paragraph. You are Ms. Ghosh.
Ms. Ghosh.
Ms. Orijita Ghosh.
My lord.
Learned counsel appearing for the respondent begins her argument but does not conclude. Paragraph. When?
Monday, my lord.
Monday, Friday?
Friday, I believe Mr. Banerjee is in some difficulty.
We are hearing you.
My lord, I think I'll also won't be there.
Very well. As requested, list the matter once again on Shamli Shombar, retaining its position. এগুলো নাও।
Monday,
You are not there on Friday?
Pro bono matter, Lordship.
Not this one. You have some pro bono matter to do.
Always told that pro bono should be given first priority then.
Yes, yes.
Court Master Ji, will the court come back again or they've risen for the day?
I was a bit apprehensive because of Friday's development.
Yes, yes, yes.
Whether it will continue even till today. Anyway, thanks to everybody concerned that we can try to finish it. Not for the online submission, I had addressed your lordship on different aspects of the law, and your lordships were pleased to tell me that that I need not address your lordships on the cases cited by Mr. Bandyopadhyay. Therefore, my lord, I am not going there. Only two things I have to tell your lordship. Iman Bosch's case, which was cited by Mr. Bandyopadhyay, really is in aid of my submission. In paragraph 17 of the judgment, that is handed up to your lordships, that's what was a reference to 2010.
SCC 673.
Yes.
Yes.
Kindly come to paragraph 17 of the judgment. The question that arises in the present case is whether the High Court can entertain a contempt petition filed by a private person without the consent in writing of the Advocate General. For the determination of this issue, it will be relevant to note the observations of the HON'BLE Committee, whose recommendations were taken into consideration for enacting the Act. The committee observed, my lord, observation of the committee, I am not troubling your lordship with that. Now, my lord, if your lordship kindly comes to paragraph 18. First is SK Sarkar approvingly refer to the recommendations of the HON'BLE Committee. And next, it can be said to have taken cognizance on its own motion. But if the High Court is directly moved by a petition by a private person feeling aggrieved, not being the Advocate General, can the High Court refuse to entertain the same on the ground that it has been made without the consent in writing of the Advocate General? Here, no petition has been filed, only information has been made available to the court. It appears to us that the High Court has, in such a situation, a discretion to refuse to entertain the petition or to take cognizance on its own motion. So, even if a petition is made, High Court can take note of it on its own motion, on the basis of the information supplied to it in that petition. Therefore, my lord, a petition is not totally ruled out.
Petition will be treated as information.
That's right. If the petitioner is a responsible member of the legal profession, it may act suo motu, more so if the petitioner advocate, as in the instant case, prays that the court should act suo motu. But in my affidavit, it's affirmed by a practicing lawyer of this court. Therefore, credence factor is taken care of. And secondly, my lord, there is a paragraph which says, on the basis of the above facts, the court may kindly take suo motu notice of it. So, as is decided by the apex court, this is the whole object of prescribing these procedural modes of taking cognizance in section 15 is to safeguard the valuable time of the High Court or the Supreme Court from being wasted by frivolous complaints of contempt of court. This is not one such case that the contempt application is, or the information is such that's frivolous. If the High Court is prima facie satisfied that the information received by it regarding the commission of contempt of a subordinate court is not frivolous and the contempt alleged is not merely technical or trivial, it may in its discretion act suo motu and commence the proceeding against the contemptor. However, this mode of taking suo motu cognizance of contempt of a subordinate court, we are not concerned with that. It's not a case of contempt of subordinate. Next, we are paragraph 23. It is settled law. My lords have kindly got it. It is settled law. The High Courts, even while exercising their powers under Article 215 of the Constitution to punish for contempt, the procedure prescribed by law is required to be followed. The High Court in the present case relied on the decision of the court in Sikha Daftari and O.P. Gupta, wherein this court overruled the objection raised on behalf of the alleged contemptor that the contempt petition filed in Supreme Court without the consent of the Attorney General was not maintainable. The decision was rendered prior to the act coming into force. But this is where one distinguishes this thing. That was prior to the act. Now, after the act, can you give a go-by to section 15 or rule 15? Lord, if your lordship kindly comes to paragraph 24 now. Lord, placitum E. There is nothing on record suggesting that the contents of the petition were treated as information placed before the court for initiating the contempt proceedings suo motu by the court. Therefore, here twice, primarily the Honorable Chief Justice was satisfied. It's a grave case of contempt. That is why it was referred to a special bench. And your lordships, on the very first day, considered it and observed that prima facie your lordships are satisfied that a gross criminal contempt has been committed. And that is why show cause notice was issued. And after there was no show cause taking place, your lordships were pleased to issue a rule. Now, Lord, next one. The petition itself is not styled as any piece of information that was placed before the court for its consideration. It is not a case where the High Court refused to entertain the petition and took cognizance on its own motion on the basis of the information supplied to it in the petition. The record does not bear. Therefore, Lord, Biman Bosch's case was decided absolutely on different premises. But it Lord, supports us, because if these factors are there, then Lord, Biman Bosch's case goes out of the way. Now, Lord, once, next paragraph, third line. But once those facts are placed before the court, it becomes a matter between the court and the contemptor. But such person filing an application or petition does not become a complainant or petitioner in the proceeding. His duty ends with the facts placed before the court. The court may appropriate cases in its discretion require the private party or litigant moving the court to render assistance during the course of the proceedings. But your lordship, remember, I told your lordship that I am nowhere. If your lordships require any assistance from my end, I shall be. Now, Lord, I believe. Yes.
Correct. Correct.
Lord, the rest part of Biman Bosch's case, court says, a petition without consent of the Attorney General or Advocate General will not be maintainable unless it has to be read as a whole, unless those factors are there. But I don't think I should trouble your lordship anymore with this judgment. Next. Now, my lord, just share the copy now. My lord, 2025 SCC online, Supreme Court 1011. The Lordships, kindly come to paragraph 13 straight away. Because earlier cases are considered, I need not waste your Lordship's time by taking your Lordships to those, HON'BLE and all others. A 3-judge bench of this court in Pallav has held thus, 30 is quoted. There can be no doubt that both this court and the High Courts are courts of record. This is the submission that I made before your Lordships. Courts of record. And the Constitution has given them the powers to punish for contempt. The decision of this court clearly show that this power cannot be abrogated or stultified. But if the power under Article 129 and Article 215 is absolute, can there be any legislation indicating the manner and to the extent that the power can be exercised? If there is any provision of the law which stultifies or abrogates the power under Article 129 and Article 215, there can be little doubt that such law would not be regarded as having been validly enacted. It, however, appears to us that providing for the quantum of punishment or what may or may not be regarded as acts of contempt, or even providing for a period of limitation for initiating proceedings for contempt, cannot be taken to be provision which abrogates or stultifies. Now, as I submitted, if it is, the power is derived from Article 129 or 215, the power emanates from the Constitution. No legislation can take away that power. Therefore, Constitution does not say, without the consent of the Advocate General, without the consent of the Attorney General, it is enacted in the Act. Whether the Act can provide that requirement, which does away with the constitutional power. Now, my lord, if your lordship now kindly comes to paragraph 41, one of the principles underlying the law of limitation is that a litigation must act diligently and not sleep over its rights. In this background, such an interpretation should be placed on Section 20 of the Act, which does not lead to any anomalous result, causing hardship to the party who may have acted with utmost diligence, and because of the action on the part of the court, a contender cannot be made to suffer. Interpreting the section in the manner canvassed by Mr. Venugopal would mean that the court would be rendered powerless to punish, even though it may be fully convinced of the blatant nature of the contempt having been committed, and the same having been brought to the notice of the court soon after the committal of the contempt, and within the period of 1 year, the same. Section 20, therefore, has to be construed in a manner which would avoid such an anomaly and hardship, both as regards the litigants as also by placing pointless fetter on the part of the court to punish for its contempt. An interpretation of Section 20, like the one canvassed by the appellant, which would render the constitutional power of the court nugatory in taking action for contempt, even in cases of gross contempt, successfully hidden for a period of 1 year by practicing fraud by the contemptor, would render Section 20. Now, my lord, this is a guideline for Section 20. But what is the logic behind it? The court is not powerless to punish for gross contempt on this technical considerations. Limitation is more important than this taking permission of the Attorney General or Advocate General. But I think
Based on this principle, paragraph 15 draws conclusion.
paragraph
15.
Now, my lord, kindly come to paragraph 15. It is significant to notice that the case bundle of writ petition in the High Court was misplaced in the registry of the High Court so as to render the High Court powerless to punish for contempt, even though it may be fully convinced of the blatant nature of the contempt, and the same having been brought to the notice of the court within 1 year from the date of commission of contempt. Such situation was clearly foresighted by this court in Vallabh versus Shade by observing in paragraph 41 that section 20 of the Act therefore has to be construed in a manner which would avoid such an anomaly and eventually. Now, Lord, I am really relying on this. Section 15 or Rule 15 has to be construed in a manner so as not to take away the right of the High Court to punish for a case of gross contempt. In this case, I shall just address your lordship how this is a case of gross contempt which requires the court to act. So, my lord, this case says all the provisions of the Contempt of Court Act are not to be construed as taking away the right of the High Court.
Restricted to ordinary legislation? Restricted to ordinary legislation.
My lord,
Paragraph 16, 15.
Next case that I place reliance on is 1993 Supplement 1 Supreme Court cases 529. Kindly come to paragraph 15.
No. We don't. No. Further.
Prior to the Contempt of Courts Act 1971, it was held the High Court has inherent power to deal with the contempt of itself summarily and to adopt its own procedure, provided that it gives a fair and reasonable opportunity to the contemptor to defend himself. Here, there is no complaint in that regard. But the procedure has now been prescribed by Section 15 in exercise which was conferred by Entry 14, Section. Though the contempt jurisdiction of the Supreme Court and the High Court can be regulated by legislation, by appropriate legislation under this entry, in exercise of which Parliament has enacted the Act of 71, the contempt jurisdiction of the Supreme Court and High Court is given a constitutional foundation by declaring to be courts of record under Articles 129 to 15, and therefore the inherent power of the Supreme Court and High Court cannot be taken away by any legislation short of constitutional amendment. In fact, Section 22 of the Act lays down the provision of this Act shall be in addition to and not in derogation of the provisions of any other law relating to contempt of courts. If it necessarily follows that the constitutional jurisdiction of the Supreme Court and the High Court under Article 129 and 215 cannot be curtailed by anything in the Act of 1971. Now, this has been further elaborated or Lord, Lord, kindly see paragraph 41. The position of law that emerges. There's an inherent power and the jurisdiction does not derive from the act of any other statute. but from Article 129 and 215. And therefore, the constitutional power cannot be breached. This is as per back as in 88. Now, Lord, all the English laws and other things are considered. I don't think I should trouble your lordship and waste your lordship's invaluable time. আমার বান্ডিলটা কোথায়? ওইখান থেকে বার করেছো? ওইখান থেকে বার করো, আমরা দাগ মারা আছে সব। Lord,
41 বলছে, nor can the power be controlled or limited by any statute or by any provision of the code of criminal procedure or any rules.
Lord, is any observation troubling your lordship?
41, no, not troubling.
Yes.
41, if you just carry on where you stopped after that.
You will kindly see. The vestige is a special one, not derived from any other statute,
Yes.
but derived only from Articles 129 and 215 of the Constitution. And therefore, the constitutionally vested right cannot either be abridged by legislation or abrogated or cut down. Very wide.
The next sentence.
Nor can they be controlled or limited by any statute or by any provision of the Code of Criminal Procedure or any rules. So, not contempt of court rules are simply rules. If the act cannot curtail, the rules also cannot curtail. And the caution that has to be observed in exercising this enhanced power by summary procedure is that the power should be used sparingly, and the procedure to be followed should be fair, and that the contemnor should be made aware of the charges. All these are fulfilled, and Lord, this is not a case of it. Trifle, ignore it. No. Lord, two things your lordships will kindly keep in mind. A sitting judge of this honorable court, his picture is taken and put under the foot. Trample. That is how this judiciary is being treated. Lord, if I digress for a moment, lordships, remember, in Justice Rajashekhar Manta's case, posters were pasted in the vicinity of his house, so that locality people, they can know that look here, this is what has been done. Until today, the police has not been able to identify who were those persons. Where does the judiciary stay? Where does the judiciary stay? So, my lord, it is time. I say it's high time that your lordships take a stringent view of the matter. That this cannot be tolerated anymore.
চিফের প্রথম যে অর্ডারটা ছিল সেটা কপি এইটা একটা না, এটাতে পাচ্ছি না, তো স্যার প্রত্যেকবার এটা একটা করে দেবেন।
Lord, the lordship kindly comes to paragraph 56. Last two lines, Justice Ahmedi's judgment is quoted. The tendency of maligning the reputation of judicial officers by disgruntled elements who fail to secure the desired order is ever on the increase, and it is high time that it is nipped in the bud. And when a member of the profession is also such tip, I put it this way, when responsible, supposed to be responsible persons do this, then not very serious notice has to be taken of that. Then not kindly come to paragraph 59. Placitum H, just above that. these calculated contemptuous remarks and the sweeping allegations which we have extracted above are derogatory in character, not only to the dignity of the learned judge and casting aspersion on their conduct in the discharge of their judicial functions, but also wounds the dignity of the court. So not forget about this judge concerned. Think it as an institution involved. I can tell you, Lordship, one thing. If this is tolerated or the contemners are allowed to go free, then the message that will go is we can do anything we like. Court is powerless. In the name of mercy, justice must be tempered with mercy. Therefore, in the name of mercy, let not justice be a casualty.
Attack on lawyers and threatening.
Lord, next case that I cite is a division bench judgment of the Bombay High Court. Why I cite this is the lawyer was certain, unless you withdraw, you'll have to face consequences. Lord, paragraph 18. The view taken by the Nagpur High Court has been endorsed by the Allahabad, Madras and Lahore High Courts. In Rajendra Singh versus Uma Prasad, during the pendency of the suit, a notice was sent on behalf of the plaintiff through his advocate to the defendant, threatening him that unless he withdrew from the plea and paid a certain sum as damages, he would be criminally prosecuted for defamation or attempting to prevent the defendant from facing the plea, which might have to be a very substantial and legitimate defense. And in that way, an indirect attempt was made to exclude that plea from the consideration of the court. Now, Lord, what is done in this case? The litigants assemble, shout slogans, try to bracket a lawyer with a judge. That setting will not be allowed, and we will not do this case before this judge. Now, Lord, here, may I pause here for a moment and take, I request your lordships to take a judicial notice of the fact that only a few days later, in a case regarding Jogesh Chandra Chaudhary Law College, when judgment was being dictated by the same learned judge, when an advocate general entered and said, in the middle of the judgment, I have not completed my submission. People say, all right, you completed that. No, we don't want your lordship to hear it. Kindly release it. Whether your lordship will permit such things to occur and recur, it's up to your lordships. After all, I have no what is the matter between the court and the contender. Blood. Not gotten you.
19 last line 18 line code.
Paragraph 19, last line. Secondly, the threat need not be direct in the sense that the contemner specifically asserted that he would take such action. It is sufficient if the context showed the action contemplated was the action of the contemptor himself. A similar question arose in such and such case. Therefore, kindly come to paragraph 20. This is a foreign case considered. Quotation: advocates who appear for the parties, being officers of the court, any abuse or insult or aspersion cast on them which would interfere in the course of administration of justice must necessarily be held to amount to contempt of court. Now, there are two parts. One is threatening, another is discrediting. Both are equally cases of contempt. If I don't threat, but I discredit him, look here, this lawyer has a lineup with such and such judge, and therefore he gets orders. You're not discrediting the lawyer. This is not something which should be permitted in my very respectful submission. Now, Lord, 22 also.
It was held.
In Nandhala versus Kishorilal, the inspector of police issued threats and threatened in the performance of his duties, and although there was no contempt of the court directly, there was contempt in as much as an officer of the court, such as an advocate, appearing in his professional capacity, was threatened and insulted while in the performance of his professional duties. Remember, while in performance, I read this way, not that within the courtroom only. When he goes out to his chamber, if the prohibition is read, inside the courtroom you cannot, but go to his chamber and shout slogans. You're trying to discredit the lawyer in the eyes of the people. And an officer of the court does not deserve that. Now, Lord,
last three lines. Last three.
Lord, paragraph 23.
Last taking overall.
Lord, and taking, Lord, last 4 lines. Paragraph 23, next page. And taking an overall view of the matter and having regard to the entire conduct of the defendant, and further taking into account the circumstances that the threat was uttered in course of the arguments and in presence of the judge, we feel no hesitation in holding that the threat was intended to operate upon the mind of the counsel so that he should flinch from the performing his duty towards his client. Now, if someone goes to my residence and shouts slogans, tomorrow, even if I don't care, my members of the family will say, you need not be in such a matter where your prestige is at stake. This is a well thought of plan. Go there, shout slogans, in the High Court area, everybody will. Then no.
Just paragraph 20.
And now, my Lord, I finish this judgment.
Paragraph. What the action, in our opinion?
My Lord, 4 lines from the bottom. The action taken in this case.
Paragraph 27, last 4 lines.
Paragraph 27, last 4 lines. The action taken in this case against the respondent by way of a proceeding against him can, in our opinion, have only one tendency. When I placed this definition of criminal contempt, I emphasized not only doing, but if it has a tendency to do it. Here it's highlighted. Tendency to coerce the respondent and force him to withdraw his suit or otherwise not proceed. If that be the clear and unmistakable tendency of the proceedings taken against the respondent, then there can be no doubt that in law the appellants have been guilty of contempt of court. even they were merely carrying out the instructions contained in the circular letter. So, my lord, this is all about this particular case.
In
What
the
about the-
videos which you produced, Mr. Sengupta, in the videos,
Yes.
the worst allegations which could be leveled against them, apparently, this is subject to, they may clarify
Yes,
it. One is that insinuations were made about complicity between the judge and counsel for the petitioner. This was one. Secondly, that demand that the matter be removed from that bench by the the CJ, and that the judge was unnecessarily insisting upon further affidavits, thereby delaying the matter. This was a specific allegation made in particularly in video number 16. And also there were serious allegations against the council, virulent attack against the council. Attack against the council was twofold. One was political, we are not interested in that. Maybe, and there were allegations they had taken matters and all. That is the political aspect, we have nothing to do with that. But whether it can be construed as interference with the administration of justice because the counsel who are appearing in the matter, specifically linking them with the matter, they being sought to be browbeat. So whether that amounts to interference with the administration of justice, this can be the highest case made against them.
I tell your lordship.
And the video of the person who the container number 8 probably
Yes.
8 probably that the worst thing which apparently is there. One stray line at 2 minutes of the video is there that the judge favors a particular political party. That we could hear. And 15 minutes, 30 seconds addressed to the judge, your court is being used by some people as their political platform.
Yes.
These are the worst allegations against
সিকিমের উকিলদের দেখলে তো জজ সাহেবদের
a particular political party. These are the worst allegations against them. And regarding the trampling of the photographs, it's not very clear whose photograph was being trampled.
Yes.
But if
very
you can
clear.
point out to the particular photographs which are,
Yes.
because there were certain images given in the pen drive also.
The copy. that we have-
Apparently, the outline, the silhouette of the photograph could be found out, and it apparently matched the photographs of the judge. Photographs of the judge were held up, that is very clear. But whether those are the photographs which are being trampled, not sure.
Lord, I just dispel your lordship's doubt. Enlarge করতে হয় দাঁড়াও আমরা দেবো আমি কালকে রাত্রিবেলা পড়েছি বাবা পরিষ্কার দেখা যায় Lord, I shall ছবি যাওয়ার পর যেটাতে পরিষ্কার বোঝা যাচ্ছে I have seen. Well, if your lordship comes to the affidavit upon by Amitabh Ghosh, which is the starting point of giving information, kindly come to pages.
Yes. আচ্ছা আচ্ছা
খুবই আছে
কোথায় দেখো ওইখানে আছে না
ফার্স্ট 2-3 পেজের মধ্যে এইখানে
Lord, page 16.
Yes.
If your lordship
Yes.
is
16 it is clear.
is clear. And even the police report also is clear.
Color coding খুব সাবধানে। Thank you.
And the police report also says that. Therefore, my lord, there is no question of any doubt that the honorable judge was sought to be. Lord, if your lordships now come to paragraph at page 21. Can you see? আজ কুণাল বলেন এসএলএসটি শারীরিক শিক্ষা ও কর্মশিক্ষা চাকরি প্রার্থীদের কেন্দ্র করে হাইকোর্টে একটি ঘটনা ঘটে। প্রতিনিধিরা দেখা করতে আসেন, কাইন্ডলি মার্ক দিস সেন্টেন্স। এদের অবিলম্বে নিয়োগে যে স্থগিতাদেশ আছে তা তুলে নিয়োগ করা উচিত। So here the stage demonstration, then go to him and he espouses their cause and say it should be done. Next page. বিস্ফোরক তৃণমূল নেতা কুণাল ঘোষ, সিপিএম কে ব্যানার্জি আক্রমণ তার। আই এম নট অন পলিটিক্যাল স্পেক্ট। একজন তারপরও সিপিএম নেতা কর্মী ছবি দেখালেন, তিনি তারপর প্রশ্ন তুললেন। এক সময় যে সিপিএম নেতারা
This page is entirely political.
I tell you one thing. I tell you also one thing. Next page is not political. বস্তুত শুক্রবার নজিরবিহীন ঘটনা সুপারনিউমারি পোস্ট সংক্রান্ত মামলায় দ্রুত রায় দেওয়া হচ্ছে না কেন, এই প্রশ্ন তুলে কলকাতা হাইকোর্টের বাইরের আন্দোলন একদল চাকরি প্রার্থী। শোনা যায় আইনজীবীদের বিরুদ্ধে স্লোগান, বিচার বিরোধীদের বিরুদ্ধে স্লোগান। এই নিয়ে বিক্ষোভকারীদের পাশে দেখা গেল তৃণমূল নেতা কুণাল ঘোষকে। সো হি ইজ জাস্টিফাইং দেয়ার অ্যাকশন। আজ কুণাল বলেন এসএলএসটি শারীরিক শিক্ষা ও কর্মশিক্ষা চাকরি প্রার্থীদের কেন্দ্র করে হাইকোর্টে একটি ঘটনা ঘটে। প্রতিনিধিরা দেখা করতে আসেন, এদের অবিলম্বে নিয়োগে যে স্থগিতাদেশ আছে তা তুলে নেওয়া উচিত। এরা সকলেই যোগ্য। বাট হি ইজ আ সুপার জাজ। He is a super judge.
But can't he have an opinion espousing the cause of these people?
I say no.
Does it appear amount to contempt?
Yes, subject to correction by your lordship.
Yes. Someone can espouse their cause.
Then he must be fair enough to come and say.
Others will be doing judicial terrorism, Mr. Shenutha. If a matter is pending before the court, nobody can have an opinion of the.
My lord, supposing I have the position to influence public opinion, then if I say something of this nature, the image of the judiciary is tarnished. And if that, Lord, Tom, Dick and Harry like Parthasarathi Sengupta says something, it doesn't matter. No one will ever.
If that is your level of, then we will listen to Tom, Dick and Harry.
Now, I never said in the corridors of High Court. I said in the streets.
We know what happens because we were all advocates.
That's right.
So we know what we say when we go outside the court.
So,
everything cannot amount to contempt, sir.
Lord, I tell your lordship. CBI এর কোনো অভিযোগ নেই, the one I was reading.
Yes.
সেই কারণে মুখ্যমন্ত্রী রেকমেন্ডেশন লেটার দিয়েছেন, কিন্তু তারপর সিপিএম এর উকিলরা এদের পরিবারকে জটিলতায় ফেলেছেন। এই স্থগিতাদেশ দীর্ঘদিন ধরে চলেছে। আইনজীবী কাইন্ডলি আস্ক দিস, আইনজীবীদের কাছে ওরা যাচ্ছেন, বিচারপতি যা চাইছেন তাই পাচ্ছেন।
This was there in the video also, and a particular political party was named.
Yes. ফের সিপিএম আইনজীবীর ফাঁকড়া তুলছেন। তিনি এও বলেন, আর বিচারপতির কিছু কিছু সিপিএম এর আইনজীবীকে দেখলে কি হয় জানি না। If this is not contempt, I do not know. A man in the street who is likely to be influenced by this. Look here, what is happening? My lord, if I may tell your lordship by way of digression, one incident. Justice Mukul Gopal Mukherjee, as his lordship then was in our court, told me this personally. I had a very good relation with him. I said, what is happening in this court? He said, do you know my experience? What? Well, I was traveling by a train. The moment one could identify that I'm a High Court judge, a person came and sat by my side and said, sir, apnar ghore maduli ke? Why we take information from outside? Since I get you, I want to know from you who is. Now,
Fair enough.
Fair enough. And
asked him directly.
And directly, because then there will be no mistake in identifying the person.
স্যার এখন কি করবো?
Yes.
When Mr. Bandyopadhyay was making submission, he also dragged Justice Abhijit Ganguly's episode, saying, yeah, no hearing was given, order was passed against person. But for that, the appeal court is there, up to the Supreme Court. This is not a forum where you could do this. And Milord Fellowship sees, our বিচারপতির কিছু কিছু সিপিএম আইনজীবীকে দেখলে কি হয় জানি না, মানুষে কি হয় জানি না বলেছি, খুশিও হতে পারে, রেগেও যেতে পারে, but not that. Everybody understands the insinuation that is being made. Lord, it is not like a person who has been sent from the United Nations to be a judge, as
Yes.
as in justice, what was judges?
International Court of Justice.
International Court of Justice.
Supreme Court of Justice. So International Court of Justice. Yeah, that's a different thing.
Was sent to the proper forum.
I know.
Forum was there.
Your Lordship was supposed to give him directions also.
Yes.
Go there this way and then turn left.
But that court was not sitting there.
The Chief Justice was saved the embarrassment.
Had advance information.
Now, kindly see, I am not on the lawyer aspect in this. If your Lordship kindly comes to Kunal Ghosh's affidavit. If your Lordship kindly comes to respondent number 8's affidavit. What is the context?
পড়ে যাবো না।
Conversation.
Text. এটা কার?
কুণালের সঙ্গে হোয়াটসঅ্যাপ মেসেজ, যারা প্রোটেস্টও তাদের।
Annex C how has been annexed. Let me see. Lord, I'm told by my Lord Junior that page 25 has been dealt with by Mr. Ghosh, respondent by 8.
This is Ghosh's affidavit, but he
That's it.
says,
Kindly see, স্যার এখন আমরা কি করব যদি একটু আপনি জানান, কিছু যদি একটা ব্যবস্থা করে দেন। Now the point is, if such a person says that I just rang up and say, देखो देखो मुझे सुझे करो, that's the language used by the ঝামেলা জরিমানা।
That's the next page.
Yes. আমি নিউজ 18 স্টুডিওতে এখন ফোন ধরতে পারছি না, যা প্রতিবাদ করবেন আইন না ভেঙে, আইনে না জড়িয়ে সাংবাদিকদের বলুন। The point is, he was in the know of everything because he was contacted over phone. And told, doesn't say, stop it. You can't do it. So it's just adding fuel. All right. I'm done.
so well planned for.
Now, my Lord, this being so, your Lordships wanted me to address your lordships on respondent number 8's complicity. And the question that just now fell from my Lord Justice Bhattacharya, that if the court is doing something, matter is pending adjudication, can one not make a statement? One can make a statement.
Yes, Mr.
Now, my Lord, before I proceed further, I just draw your lordship's kind attention to another judgment reported in 2014, volume 7 Supreme Court cases, page 280. Kindly see, yeah. Here, an unconditional apology was tendered on 21/11/2009, where the matter was taken cognizance of on 12/11. That means within 9 days. And he said, I was misguided with the advocates of District Mirat. And he was in great mental tension as his nephew had been murdered. So this is the mental state. So I tender my apology. Now, my Lord, kindly come. What is it?
89.
Yes. Kindly come to paragraph 15. The appellant, my lords have kindly got it. The appellant has tendered an absolute and unconditional apology, which has not been accepted by the High Court. The apology means a regretful acknowledgement or an excuse for failure. An explanation offered to a person affected by one's action that no offense was intended, coupled with the expression of regret for any that may have been given. Apology should be unquestionable in sincerity. It should not be tempered with a sense of genuine remorse or repentance, and not a calculated strategy to avoid punishment. Next, paragraph 17. In LD Jaikwal, this court noted that it cannot subscribe to the slap, say sorry, and forget. So, Lord, slap, say sorry, and forget. School of thoughts in administration of contempt jurisprudence. Saying sorry does not make the slap a poorer. So an apology should not be a paper apology. An expression of sorrow should come from the heart and not from the pen. For it is one thing to say sorry, it is another to feel sorry. Now, my Lord, paragraph 18. Oh, I'm sorry. My learned junior is right. I missed one portion. Paragraph 16. Just Placidum C. Undoubtedly, an apology cannot be a defense, a justification, or an appropriate punishment for an act which amounts to contempt of court. An apology can be accepted in case where the conduct for which the apology is given is such that it can be ignored without compromising the dignity of the court. So, not only in such cases. Now, apology cannot be accepted in case it is hollow. There is no remorse, no regret, no repentance, or if it is only a device to escape the rigor of the law. Such an apology can merely be termed as paper apology. Now, my lord, paragraph 18, just above Placidum G. However, even if the analogy is not belated, the court finds it to be without real contrition and remorse, and finds that it was merely treated as a weapon of defense. Next, paragraph 19. This court has clearly laid down that an apology tendered is not to be accepted as a matter of course. And the court is not bound to accept the same. The court is competent to reject the apology and impose the punishment, recording reasons for the same. Now, therefore, I very respectfully submit that a person holding a very important position in social life, if he makes such comments and observations which tarnish the image of the judiciary, should he be let off? That's your lordship's consideration, because I have no one to say, because I'm not. Only one thing before I conclude. Your lordships directed the police to investigate and give report. In the report I have recorded, I have seen marked that they say it's underway. So far, we have been able to look at 16. But not my only question, if I may be permitted to think aloud. Was any attempt made from these persons which you have been able for, where from the poster was printed? That will immediately show who are behind it. Lord,
when will you come back? Have you concluded?
I think I have concluded. Actually, only here.
You now.
Lord, on the same June 2011, 7 Supreme Court cases, 776, paragraphs 23, 24, and 25. আমি কি করবো? আমার তো আর নাথিং করবো, যেরকম রাখবেন, আমার তো শেষ হয়ে গেল। Lord, I'm grateful to your lordships
Thank
for giving me this opportunity to assist your lordships. And Lord, in fact, let me say, read one sentence of this judgment, paragraph 34.
34?
34.
You said 23 to 25?
No, that's the principle.
I see.
In this case, paragraph 34, apology tendered by the appellant gives an impression that the same was in the alternative and not a complete surrender before the court.
Of his affidavit is...
So here, I'm taking my defense. And if the defense fails, well, I'm tendering my apology. This apology is not, in my respectful submission, to be entertained.
Paragraph 5, he was waiting for the state's response, so this cannot be his unconfident.
Paragraph
5 of his.
Lord,
Now we'll hear you first next day, and then Mr. Ghoshal, who else remains? Anybody
Only,
else?
only, I think
You will address, and Mr. Mujumdar. Acha.
only request, if I may make to the bench, my lord, first to fifth, I'm not in India, my lord. If it can be taken up, my lord, on 8th, my lord.
Tell us. Bol.
Any 8th, 9th, 10th, any day, my lord, any day.
আমরা একই তো 10th 10th 3:30
Absolutely fine.
হারিউন আগের দিন অর্ডার দিই Mr. Partho Sharathi Sengupta, learned senior counsel, resumes and concludes his submission on behalf of the informants. Oh, sorry. Resumes his submission, resumes his argument, but does not conclude. Paragraph lists the matter once again on September 10, 2025, marked 3:30 p.m.
Obliged, my lord.
Thank you.
Deeply obliged.
Deeply obliged.